Apparently, there is some negotiation going on between all the parties. So it may be posted after the BU vacations. All of us are.
On 18th, my lord, if it is not inconvenient.
Okay.
Mr. I. Chaudhary, Lance Area Council. Appearing for the petitioners. And Mr. N. Deka. Learned Council appearing for the one number 2.
For the private respondent, my young friend appears.
Mr. N. Gautam.
For our
Learned Council for the respondent number 4. Have conjointly submitted that. Some discussion
My lord.
are going on between the parties outside the court. And in that view of the matter, they have submitted that matter be listed after 2 weeks. Mr. S.S. Roy, Central Government Council.
Lordship, 1 and 5.
For the respondent number 1 and 5 is also present. Also as submitted by the parties. Kamal is the case on 18.
Interim has to come.
Interim order forthrightly should continue.
Obliged.
May it please your lordship, I beg to mention item number 10, lordship. My senior NNB Chaudhary is leading in this case, but he is out of station. So kindly the matter may be listed after a week, lordship.
Item 10.
Thank you.
On the pair of Mr.
PK Basu.
P.K.
not
Basu,
missed on-
Learned Council appearing for Mr. NNB Chaudhary, Learned Council for the petitioner has submitted that Mr. NNB Chaudhary is out of station due to personal reason and has therefore the case be listed. Has therefore prayed that case be listed after 2 weeks. It is submitted that consent has been taken from the Learned Council for the respondents. You have informed the other side.
I was not informed, Lord.
I was
He is out
searching,
of station.
lordship.
He's out of station. I am person no one. Bonga municipality.
Mr. K. Mahaloy, Learned Council for the
Bonga municipality.
Huh?
Bonga municipality.
okay respondent municipality
One.
board. Is present, perhaps a consent will be given. I'll leave the case after 2 weeks on a date to be fixed by the office.
Much.
May I plead your lordship? I beg to mention for listing WPC, lordship. 5700,
WBC for what? Subject matter?
land dispute.
Pending.
Yes, lordship.
Yes, for admission.
Motion
Motion. Okay.
for tomorrow, lordship.
Tomorrow, Monday.
Monday. Much obliged.
May I plead your lordship? I beg to mention for listing dated 8/1/2024 regarding the forest matter.
What is admission column?
Sir, admission.
In the admission column. 8-1 vote as no? 10. 10. Correct it to 10.
Item number 1 for motion.
Yeah, just before I start, I just tell your lordship that I have gone through the entire petition very thoroughly. I think it will be difficult, I feel, on your part, your lordship to take a different view. I'm very honest to it.
Because
Sometimes argument a whole day, it becomes zero, my lord. This is my feeling as a senior, I am telling your lordship. Secondly, there is a judgment of Assam Board of Revenue, which your lordship will find it difficult. Because their judgment is 107 figures declared as hospital. So how your lordship will take a different view?
two obstacles.
Yes. So that's very difficult to me satisfy and saying that no, this will be a different interpretation. That is, at least I cannot find a different interpretation. I know some lawyers may find. For me, it is very difficult. I try to find it out. Some solution which may help, or your lordship may discard it, different thing. This will be a big obstacle. Thirdly, my lord, the matter has been, we have challenged of the judgment of the learned single judge to division bench. This is only a grant to appeal and my lord continuation which is pending. Now, this my lord judgment, this writ petition, either your lordship, that's my subject to your lordship correction, sends it to division bench. No, just one. My lord, this is my view. Of course, your lordship can discard. This is my
No,
particular.
that is a difficulty. Otherwise, it would have been,
or
that
otherwise.
prayer should have been made by you before the division bench.
Correct. That's what I'm saying, my lord. That's what I'm.
Because I
I'm
cannot
coming
send it to
second.
a division.
Your lordship cannot send. That's why I'm coming second, my lord. Either I have to make an application before the learned, the master of the roster is the chief justice, acting chief justice. That this is here what we have. Now, subject to what the division bench says, yes, we will bring the record from the learned single judge. It is the division bench which can be done. So I thought, my lord, before starting, I should place it before this court. These are the obstacles which your lordship will find it difficult. I am finding it difficult also.
Because I expressed that two obstacles. One is revenue board.
Yes.
Second is that view of the coordinate bench is to be respected by the
Well, that's
other
a-
coordinate
My
bench.
lord, this is what is tradition we are
That is
following.
consistency,
My lord-
propriety
My lord,
demands that. It will be difficult. And thirdly, sending it to division bench is
no,
also.
these are three difficult. So I thought of going through it. I said, that let me place it. Whole day your lordship has to hear it. Ultimate end result is what the end result. Maybe we always argue end result is up to the court. But these I find difficult. So what I argue, then your lordship again comes back. When I am going through it, facts of again goes back to Assam Board of Revenue, which a review application has been filed. I told my learned friend that you should pursue the review application, filing an application there itself.
And somehow you.
What we can do it, my lord. My lordship will not think that we are taking some adjournment. If your lordship wants, we will argue it. But I think that we should file an application immediately before Chief Justice acting today itself. This is what has happened. If possible, we'll mention it before the court tomorrow. Let your lordship wait till Monday, because heaven will not fall. Ultimately, it's a judgment which has been passed and your lordship is protecting it. Let it come on Monday, this matter. In the meantime, we'll inform your
Yes,
lordship.
Mr. Borpuzari.
I am led by the learned advocate general. He is coming, my lord. He is stuck up in court 15 in item 1. My lord, let his, my lord, presence be there, my lord. Before lordship fixes the matter on Monday. Anyway, my lord, whatever view lordship takes. My difficulty lordship will kindly consider, because I cannot concede.
There can be three results. One is dismissal, one is retribution is
No,
allowed.
my lord, absolutely.
And
is
both
one
are in the face of this. Both
But
are.
my lord, with all respect, my lord, whatever, my lord, is forthcoming from the learned senior council.
Because ultimately this thing pertains to that 100 bighas or something like that.
107.
101 bigha.
101.
One bigha.
And in respect of, I think, few persons,
Yes.
some findings have been recorded.
Yes.
And
Owners-
also by a coordinate bench.
Yes.
Coordinate bench.
Because it was initially where in the Assam Board of Revenue, one of the predecessors came and filed it. How that 4 or 5 tenants can file an application before SDC and declare themselves as an occupant, as the owner of that land. And as the ADC forwarded that yes, you can look into this matter and you can take action, like you can give. It was put to challenge by one of. Now, of 17 bighas, entire 101 bighas of the land has been declared. Now, this is how your lordship will adjudicate. It will be difficult because there is already a judgment.
Already judgment.
Already there is judgment. So your lordship, that is why the learned single just find it difficult.
Okay.
Because there is a finding,
There is a
a
proposal.
clear finding of fact that the land in question belongs to my lord Piola Kotra. Now, unless and until my lord there are my lord convincing rebuttal evidences, if that is placed before this honorable court, then that finding subsists, my lord. That is my respectful submission.
If I try to justify also, your lordship will not touch it. Your lordship will definitely say, go before that court.
And difficulty is sending to the division bench from the single bench. That is difficult.
Perhaps my lord, the petitioners will have to make a move.
Yes.
My
I
lord.
told,
Okay,
that's
let
why.
Advocate General come.
Yes, my lord. Sometime.
He is on his way.
Yes, he is coming, my lord.
Okay.
I thought that before I
Yes.
start, I know the lordship will,
Yes,
I
that
can
is-
argue, whole day I can argue. Ultimately, whole day argument.
I am deeply obliged, my lord. Whatever my lord is submitted by learned senior counsel.
Okay.
I'm so obliged.
Item number 2.
এটা রাম প্রসিজার আছে যে রাম প্রসিজার আর এখন some land giving animals develop it up very heavy.
Lordship, there is an order for the additional advocate general, Mr. B. Goswami is appearing in this case, Lordship. Perhaps his name has not been shown Lordship, in the process.
For otherwise, he's supposed to, because on his,
On the last occasion, Lordship, I think whether REIT will end or I'll go for the criminal appeal, Lordship. That was the question that was raised, Lordship.
yes,
AG has to address on that issue.
have you made any endeavor?
Lordship, I'm sorry, could not, because I have some renovation work in my chamber, painting and all are going on, so I could not. It's time and all.
Because special
If your Lordship fix on Monday, Lordship,
special tribunal, I think special court, no?
special tribunal,
Special court or special tribunal?
Lordship,
Special tribunal.
Huh?
tribunal.
Tribunal.
Right.
Special tribunal exercises two kinds of jurisdiction,
Lordship,
right?
both criminal and
One civil jurisdiction to decide about the civil liability,
Lordship,
and thereafter criminal jurisdiction to decide about the criminal liability.
Lordship,
So it exercises both jurisdiction.
both jurisdiction, Lordship.
Petition possibly does, huh? If it is criminal jurisdiction, then it should be writ petition criminal.
Lordship. Nomenclature will change, otherwise it will-
Nomenclature will change and jurisdiction changes. Because after writ petition criminal, there will be no letter pendants appeal or intra-court appeal. Next forum is Honorable Supreme Court.
This is also 227. Whereas my petition is under 227.
Now 227, whether 227 is applicable in case of criminal jurisprudence, criminal jurisdiction.
That superintendence and control, that will always be there, Lordship, the 227. The superintendence and that will be there, Lordship. And
High Court rules concern. Can Mr. Goswami be informed? Additional Advocate General?
he was sent.
I'm looking at it.
What the reference case of division of discourse division myself said? Any idea?
Lordship.
Yes, Mr. Advocate General, yeah, or, okay. In this case, item number 2. This is a case emanating from special tribunal under the Assam Land Grabbing Act, Prohibition Act. Statute has provided for constitution of a
Special tribunal.
Special tribunal.
that has not been constituted.
Special tribunal is the judge is designated.
Designated,
Special,
Lordship.
that
sorry.
lordship, appellate court has
Appellate
not
tribunal.
been. Appellate court.
Appellate tribunals. Appellate tribunal provision is
14, section 14. Lordship.
section 14. From the designated
Yes.
special court, appeal lies to the special tribunal. There is no special tribunal constituted. Now,
There is one problem. We wanted to constitute and process was also started. Then we have to get retired High Court judges for that. And none of the judges have given consent. That is the instruction I have received. But let me explore it, what can be done. Otherwise,
because just the difficulty here is that special, another difficulty. Okay, we are taking it that there is no constitution of the appellate tribunal.
yes.
So taking that point, if we proceed, this special tribunal or court?
Court. Appellate court.
No.
Special court. Special tribunal will decide, then we have to approach the special court.
Special tribunal discharges two kinds of jurisdiction. One is civil jurisdiction. On the civil liability, it will decide whether that person is a land grabber or not. Then thereafter, the direction of the special tribunal is to evict the land grabber. Then after expiry of the time of appeal against that order regarding civil liability, the special tribunal takes up the criminal matter, criminal side of it, about the criminal liability. Then it goes on, and after trial, framing charge, it convicts the person. Now, so it discharges two kinds of liabilities.
I understand.
So for civil liability is concerned, because of non-constitution of the tribunal, 227 may be jurisprudence or supervisory jurisdiction. Criminal jurisdiction, here the persons have been convicted under Section 5 of the Land Grabbing Act. They have been sentenced to 2 years, 7 persons. They have no appellate forum. Now they have come under 226. Now 226 also, what kind of jurisdiction will exercise? 226 has two phases also. One is civil, the other is criminal.
Yes.
Now, suppose if we exercise civil, but it is about sentence
It's criminal.
conviction.
Yes.
So if we exercise civil side, then there will be division bench appeal. There will be appeal before the division bench. If we decide on the criminal jurisdiction side, then there will be no intra-court appeal. The appeal will be before the Supreme Court. So this is the issue, how this repetition is to be, the nomenclature is to be given. That is one part. And whether 227 powers are exercisable in respect of criminal jurisdiction exercised by a tribunal. Because otherwise, there are other, suppose in case of Uttar Pradesh, where 438 was kept outside the CRPC, then people started filing writ petitions and 482. And there also, there are some observations that don't exercise jurisdiction regarding suspension of sentence, something like that.
And even for no coercive action regarding bail also sometimes.
Right.
Six
So
comes.
this is the dilemma because of non-constitution of the tribunal. Now, leaving aside that, what jurisdiction will exercise here?
My prima facie opinion is 226 in both cases.
226, they have not come against civil liability.
They have
They
come
have
for
come against
criminal.
the criminal liability.
They are also lordship.
Right. So that court has exercised the criminal jurisdiction part.
I
And
fully agree.
against that, they have filed a writ petition. So this writ petition will be termed as writ petition civil or writ petition criminal. That is what I was asking on the last date. Because the consequence will be for them if they fail here.
They have to go to the Supreme Court.
There are people living somewhere in Kachar or what?
Kachar, Lord.
Kachar. So that is what.
Hailakandi, Lord.
I'll address
Because
on this point because let me examine this also. I'll come
Because
on-
it will have also consequences in other cases
Notification is
also.
there and it will lay down the law also, the pathway for this kind of situation. And in the meantime, what we have done or what is in the contemplation of the government regarding constitution of the tribunal, the appellate tribunal, I'll also update this honorable court regarding that.
Because on the civil side, 227 petitions are admitted. So far, I know. 227. Also, this 226 also, I dispose of. So for criminal part is concerned, there are serious consequences.
Lordship, I'll definitely look into it.
That is what, because on the previous that Mr. B. Goswami was supposed to go through the provisions. Since you are available.
Yes, now
here,
I will address this on Tuesday, Lordship. On 10th? 10th, not on 9th. On 9th.
9th, okay. Because
Because we also want to activate our system because lot of land grabbing cases are coming up.
but because we are, suppose we admit this petition, so far civil liability is concerned, we will not be touching
Criminal
upon that.
liability.
But their sentencing of 2 years, we may have to say, decide on it about suspension of sentence. One minute. But there is a case of Ramkishan Fauzi. Their Lokayukta, he directed, recommended registration of FIR against the one person. Then that Supreme Court has said, I have not gone through it totally. I have read it earlier. It says that that is criminal jurisdiction. So in that case, it will be writ petition criminal. Then next forum is Supreme.
So if that be the law, let it be law. They have to go whether they are from Kachar or Kam.
No. That is not a question.
They-
Difficult is,
This is a new area, Lordship, definitely. The
difficult is on the part of the court, how to register the case.
register the case.
If it is writ petition civil,
Yes.
whether we can exercise, because he has filed it
No,
as branded as writ petition civil.
No, it will
Either I have to direct
Yeah.
it
to be
the registry
re-registered.
to convert it to writ petition criminal, and thereafter that issue is to be decided first. Preliminary issue. They are at large. In the meantime, they are avoiding the process.
Taking advantage of the gray area now.
No, not the area.
Gray area.
We are not deciding it.
Yes. Then it is, I don't think this is a very major.
Kindly look into it. If there is no tribunal, then what, in what manner?
Yes, that is.
The Roger Matthew case is the 2020,
Okay.
6 SSC 1, phase 1. And I feel, my lord, that's what I feel, that there are two issues here, WPC criminal and the writ petition. Like in PMLA also, my lord, adjudicating authority is a civil. You can come under 226. But when, my lord, a complaint is being filed, that is a criminal aspect of the matter. So WPC, it will be, that's my opinion, WPC, it will be criminal. Because there's a criminal action. So it cannot be preceded by Article 226. It is only a civil, when an adjudicating authority, like a civil nature, it will be 226. Because your lordship is right, WPC criminal, this is the last court. And in 226, you can go for division bench. I think there is a circular which has issued, I think. If I am not wrong, the WPC.
On this, Ramkishan Fauji, 2017 5 SSC 533. If the proceedings, nature and relief sought pertain to anything connected with criminal jurisdiction, intra-court appeal stroke LPA would not lie. Character of the proceedings does not depend upon the nature of the tribunal, which is invested with the authority to grant relief, but upon the nature of the right violated and the appropriate relief which may be claimed. In the present case, the writ petition was filed under Article 226 of the Constitution for quashing of the recommendation by Lokayukta for registration of FIR, and the said recommendation would have led to launching of criminal prosecution. Therefore, it could not be said that the single judge, in exercise of the jurisdiction under Article 226, had passed an order in a civil proceeding. Thus, letters patent appeal not maintainable before the division bench. So all these other things, criminal
Principle is very clearly
jurisdiction,
laid down, Lordship.
Huh?
Principle is very clearly laid down.
Laid down. But I have to be sure because
We'll
there are
examine
many proceedings.
Lordship.
Lordship, can you see that?
Okay, Rosa,
Rosa Matthews.
Okay, I'll go through it. Yes, Mr. Goswami.
Passing the buck.
No. Actually,
No, no, I'll be happy.
I missed the item in fact, my lord. When
Okay.
Advocate General is there, no problem.
Mr. B. Chakraborty, the
No,
Council for the petitioner,
Let me explain.
and Mr. D. Hoja, and advocate. Assam assisted by Mr. R. Borpatari, are present as sought for by the learned counsel for the parties. Release the case on Tuesday.
Deeply obliged.
To buy your platform. Oh, Mr. H. M.R. Chaudhary, learned counsel for the aviator. Yes.
Number one.
Yes,
He made some submission.
yes, I have been briefed by myself.
Yeah.
So my submission is that Lordship, has the materials before this honorable court is sufficient to take a call instead of handing over to a division bench.
No, I'm not handing over.
Yeah, their prayer. They want that this matter should be heard by the division bench. That is not the process, and we do not want to lose one of the forum. On behalf of the state, my submission is that this case is not maintainable because the division bench has already taken, the single judge, the coordinate bench has already taken a call on this. If they want, they can file a separate writ appeal before the division bench by seeking leave and all, which they have already done. Notice has been issued. They are not remediless. But so far as this writ petition is concerned, Lordship, unless Lordship has a different opinion or conflict of opinion with the learned single judge, the ruling or the verdict will be applicable here also.
Then you have to proceed.
Ultimately, it will revolve around. That's why I said before, your lordship, Assam Board of Revenue, their judgment. That's why what I said, only a prayer is being made. We'll mention it before the court tomorrow itself. We'll mention it if the court allows, well allowed. No, otherwise Monday your lordship can take up this matter. It's matter of 2-3 days. We'll try to pursue. We'll tell this is the situation. If the court says that no, we are not, you go and proceed, you argue. It's the end of the matter, my lord. We'll tell the court because we didn't say that a writ petition has been filed. We didn't say before division bench while moving the matter. Only matter of 2-3 days. We'll make an application. Otherwise, your lordship is difficult to set it before the learned single judge.
No,
It is only the
cannot be.
chief justice acting the master of roster can. Either he brings it or he doesn't bring it. That's the end of it. On Monday, it can be taken up. It's only for two, is only today is Thursday. We'll try to mention it tomorrow in the morning itself. If the court allows, well enough. If doesn't allow, Monday you'll proceed with the hearing of the case. Only asking for 2 days accommodation.
There should be some agreement, or if there is disagreement,
No, no, that's true, man.
Simply an adjournment, if he prays for simply an adjournment till Monday, I have no objection. But if he wants to say that I'll do that,
No, it's okay.
then
A
I
simple
do not agree
adjournment.
on those principles.
this cannot be reflected.
This cannot be.
No, it's
reflected.
okay, my lord, fine.
They have some
I have to
difficulty.
tell you, Lord. I know, my lord, a simple adjournment, but I have to tell you, Lordship, what for you are asking.
Because there is a
I know,
interim
I
order
understand.
acting in their favor.
Yes.
I know, it's right, he's right, absolutely.
Okay,
correct.
otherwise Monday will proceed.
Yes, yes.
No results
Sure.
comes out
Yes,
No, no,
Lord.
after
sure.
your endeavor.
Yes, yes,
Lord.
yes, yes.
We will not observe anything in the
No,
order.
no, it's a simple adjournment.
On your prayer, I am okay. On the prayer of Mr. D. Das, learned senior counsel, assisted by Mr. J. Abbas, learned counsel for the petitioner, his petitioners. Matter stands adjourned to
I am
Monday.
expressing urgency, Lord. That may be.
I am recording.
Lord.
Mr. D. Hoikia, learned advocate general, some assisted by Mr. R. Bozari, learned standing counsel, R. Bozari, learned counsel for the state respondents, has expressed urgency. Considering the submissions made, has paid for listing of the case on Monday. Considering the submissions made, comma, the case be listed on Monday with the observation that endeavor will be made for final
Yes.
consideration, the repetition.
Right.
Highly obliged.
Interim order passed like that shall continue till the
Declared.
next date of.
I'm still. I also recollect this matter is regarding about GST and service tax matter.
Yes, yes.
And your lordship wanted to see the record on 4/9/2020.
Just have a look, if possible.
Receipt position. Online process. Online. Punto adesso potrebbe avere un divario. Copiare di memoria di non è per poter. Itu কোনো যদি এতে প্রোভাইড করা হবে বলে পূর্ণ Is very good. 21 itu 49 আছে 49 কথা বলি ওপেন করতে 49 is 36 so 36 correct.
This is not the same, page 41. Page 41. Third para. This is not the same
Yes,
letter.
That's why I was
There
telling my
is
learned
something
friend.
else. Maybe. Because this is 4/9/2020.
Reference number is also different.
And secondly, come to page 48. Clause para 1.1.
Yes,
Last 4 lines. He dealt with this 4/9/2020. Not dealt with 21/9/2020.
it is subsequent to that.
And reference number is also different.
Yes, it is different.
Okay, let us see the provisos sections, finance sector. I have forgotten.
I will just tell your lordship in 2 minutes, my lord. This is about regarding a notice was issued to us in 2021, an IBAN notice. They are saying that they came from the income tax return and SR2, that there is a survey, we have paid a gross sale and turnover in year 2015 and 16 amounting to 40 crores odd amount. Out of that, 31 crores has been paid service tax out of that. But 9 crores odd amount has not been paid service tax. We paid VAT. That's why they are saying that you have evaded. This is the case. Now, 73(1) says that there is a time limit. Within 30 months, my lord, a demand notice has to be issued. If it is not issued within 30 months, then there is a proviso. Proviso says within a period of 5 years, limitation has been given to the department. And limitation to the extent, limitation to the extent there has to be 5 conditions. Only then you can exercise that limitation. Fraud, coercive, then collusion, then misrepresentation, and so on and so forth. So forth. Now they are saying in the demand notice there is a suppression of facts. That using that limitation. This is the case which they are projecting because they said 2021, 16 means, my lord, 5 years. We are saying number one, that during the deliberation earlier, placed before your lordship, we said that number one, that this fraud or collusion or suppression has to be established. Then only you can issue a notice which has not been established. So, which is not been established, you don't have a jurisdiction even issue the notice. Then your lordship has put a query that whether you have taken this point at the first instance. Then we said in the appeals, before the commission of appeals, before the appellate court, we have taken that point. But before then, deliberated, your lordship has taken up, I have not, your lordship has pointed out regarding our 4/9/2020, that notice. That
is one of the faces of natural justice.
Now your lordship is saying is an absolute violation of principle of natural justice. It's a different aspect. Absolute means we are not been hurt. But during the course of deliberation, when we were arguing the matter, we said, we wanted some time. Please give us some time to produce those documents. Now, without giving us time, 5 days time, then he passes a judgment. Then during the course of hearing, your lordship has pointed out this particular on 1.1 at page 50, 70. Kindly see. 70, kindly see, my lord. 70, 2.0. That for the order in the original is bad, inasmuch letter bearing dated 4/9/2020 as referred to in para 1.1 said to have been issued for submission of requisite documents was never received by the appellant, which may be evident from the fact imprint so-called notice as well as order in original is consequently silent about the receipt or acknowledgement of the said letter. Therefore, the allegation on submission of document, non-payment of service tax, deliberation suppression of value of taxable service rendered by the appellant with an intent to evade payment of service tax for the period 2015-16, as mentioned, highlighted in the imprint order in origin, are vague, devoid of facts, and unsubstantiated and without any basis. This was a point which, kindly see, my lord, the finding 101. 101, 10.13. The impugn order in original based on so-called notice bearing dated 26/4 and 20 is not sustainable on ground of limitation. It is to mention here the period of dispute is for the period for April 2015, March 16. And the appellant has filed a periodical SD return for the period of half year ending September 2015, March 2016 on 25/10/2015 and 26/2016. Moreover, the income tax return for the period 2015-16 was a file long back in October 2016, whereas the so-called notice has been issued on 26/4/2021, upon which the impugn order in original passed on 1/3/2022 by invoking extended period. In the present case, there was no suppression of any kind whatsoever. The appellant was registered under service tax paid, service tax liability on time, and till their service tax returned as and when due. Since the demand is primarily based on IT return from 26 AS, the information of provision of service is well within the knowledge of department. As IT returns and information therein forms part of the government record, along with suppression is not proper. The allegation for extended period do not arise in such case and to be dropped fully. Now, in this bylaw, the finding kindly see at page 102. Regarding the extended period, kindly see para 13. In this regard, I find that the appellant at time of hearing at appellate stage has submitted copy of single page work order, award of work order dated so and so from Directorate of Information and Public Relations Dispute for award of work for multimedia campaign Vision Assam, Mission Assam against dated 7/11/2015. As per this document, the award work was for conceptualization and execution of media buying working plan for dissemination of government related information to various media platform like electronic media, outdoor publicity, etc. for multimedia campaign Vision Assam, Mission Assam. From the limited information available from this document, the only inference one can draw is the appellant was awarded contract for designing and executing a media campaign to various media platforms. Such activities clearly appear to be in nature of advertisement, service on which service tax was payable, even if the activities involve transfer of some goods. In such case, no further details have been so and so by the appellant other than this award of work. Based on this, I am inclined to believe that so and so rendered by appellant in relation to differential turnover were squarely covered under so and so service tax. So this is a finding. While the proceeding was going on before the Commission of Appeal.
Mr. Das,
Yeah.
we are confined to 4 issues. Firstly, a writ petition against an order in appeal
Yes,
where an alternative remedy exists.
right,
Right.
Right.
We are proceeding on
Correct.
that premise only,
right,
nothing else.
right,
Then a writ petition is maintainable only on 4 grounds.
correct,
One is violation of the principles of natural justice. Secondly, lack of jurisdiction.
correct.
Virus, if the virus is challenged,
And wholly without jury, yes.
and uh, uh, these are the main.
Uh.
And one more ground maybe perhaps. Now you are filing this writ petition basically on 2 phases. One is violation of principle of natural justice, and secondly, lack of jurisdiction.
Yes.
Now, so far under the proviso to section 73, there is jurisdiction.
Correct.
To condone or extend the period, how this jurisdiction has been exercised by the assessing officer is a matter which can be dealt with.
But so far as the first point, the principle of natural justice.
Yes, primacy that
No.
it has been preceded by remand notice.
No, my lord, there is a principle of natural justice has not been decided. He has not answered the principle of natural justice. My lord, your lordship said absolute violation of principle of natural.
Absolute violation of principle of justice is not there.
Now, my lord, if during the course of
One is
argument,
no notice
my lord,
and
during
no
the,
adequate notice.
no, but during the
One is no hearing or no proper
no,
opportunity.
in the meantime, there is some development takes place and they said that yes, we want otherwise violation of principle of natural justice. Let us. He
Because,
doesn't do it.
The notice started, the event started
My
on
lord,
and from
my lord, I am tell-
26th April
my
2021.
lord, my lord, but it relates correlate to 4/9/2020. If it relates to correlate to 4/9/2020, that's the
Whether
first
that
starting
is-
point.
No,
My lord,
that you have to address that 4/9/2020 or 21/9/2020 is a liability or obligation on the part of the respondent authorities under the statutory provisions. An act is to be done as per the statutory provisions.
but-
If it is not done, it is
No,
void ab initio.
no, but if this 4/9/2020, if they can't show before the court that really a notice has not been served to me, that amounts to whole thing goes, because that's the basis. They have to come with the records. Suppose tomorrow if they find the records saying that, yes, we have served the notice, then I have to address your lord.
No, Mr. Das, first you have to satisfy me that they are statutorily obligated to send such a notice dated 4/9/2020 or 21/9/2020. I am not accustomed to the provisions of this Finance Act or but right from Nazir Ahmed, Privy Council, that if an act is required to be done in a particular manner, then act is to be done in that particular manner. Right? If that is not done, then the act is void ab initio. That is a law. Now, whether it is 4/9/2020 or 21/9/2020 notice, they are statutorily obligated to send such a notice.
But if they doesn't send it, then what is the basis of demanding?
No, this
Demanding is 2021 is based on some notice of 4/9
is
2020.
absolutely clear. Demand comes show cause notice.
I understand, but
This is under the statutory provision.
maybe, but so cause is on the basis of a particular notice was asked to certain document.
No, you had the opportunity to explain that situation also
I have
after
ex-
received.
No, I have explained. They have not,
Yes.
where is the finding by them?
No,
This
so
I-
far as assessing officer, first authority is concerned, he has explained. I think that is, we have deliberated on
No,
the
that's
case.
what, my lord, but when you before Commissioner of Appeals, we have explained thoroughly, but he doesn't decide.
How this authority has appreciated the proviso to section 73,
But that's,
because he has the jurisdiction.
my lord, I'm saying that let us first, second point was jurisdiction. First one, an absolute principle of natural justice on two counts. One is, and when deliberated, we said that please give some opportunity, we'll produce this document. But I am deeply obliged because your lordship indicated on 4/9. I'm deeply obliged because that's what was pointed out. My lord, with great respect, I
Definitely.
overlooked, but 4/9/2020 was a notice which starting point of the entire case.
Now tell me that whether that is, they are under statutory obligation.
If you have indicated in the notice, that's an, my lord, then what other, the subsequent is based on the notice of 4/9/2020.
This page 35 notice is under statutory provisions. There is
But-
no doubt of
My lord,
page 35.
no, I've seen that 35, but
Whether the
But what-
earlier notice
but
was required or they are under obligation to send such
I'm
a.
telling your lordship, I'm giving an answer, very quick answer I'm giving. That when I file an appeal before Commission of Appeals, and this point was taken by us on regarding about 4/9/2020, that I have not received any demand, any notice from you. So that is specific averment was made. My lord, with great respect, the commission doesn't decide. That's the basis. You did not supply. Where is the question of giving a reply to you? Suddenly you come with a notice that in essence, at least you decided. No, 4/9/2020, we have served notice. You have received. There is no question of giving any
Okay,
opportunity.
then second opportunity was granted.
So why, which one, my lord?
Demand comes so.
I don't know. That's either 21/9/2020 from where? I have to consult. That's a mail to whom I don't know also, my lord.
Oh, page 35?
35, sorry, man. 35. Yeah, 26
If-
for
if-
2021.
That is not under any statutory obligation that 4/9/2020 or 21/9/2020. We are into jurisdiction.
I know, my lord, I limited also, I know my limitation, my
So
lord.
that is why.
In a whether Whether there is a stage.
Had this court been sitting in appellate jurisdiction, we'd have gone into that.
No, that's why I'm saying, my lord principal, your lordship decide this way or that way. Your lordship turns down my prayer, there is no question. You go before the tribunal. Because I will not exercise my jurisdiction because I am not happy with your particular submission regarding principle of natural justice. Because I have to satisfy your lordship on these 4 grounds. Otherwise, your lordship not entertain.
Out of 4, 2 is gone, only a principle of natural justice and jurisdiction.
My lord, jurisdiction point also, he lacks because first point, let us put it in this way. My first point of principle of natural justice on 2 counts. One is absolute because a subsequent notice all is on based on 4/9/2020. We are saying averment has been made before Commission of Appeals also that no such notice of 4/9/2020 was ever served on us, neither acknowledged nor received. There is no finding to this effect. This is one. So that is a basis of entire giving me a notice. Number 2, during the course of hearing, before the the Commission of Appeals, I sought for some time. Otherwise, there is a violation. My entire thing goes. He doesn't give me time. So on this ground, principle of natural justice violated. So alternative remedy, I can come up before this court. This is one. Number 2, my lord, regarding jurisdiction. He has got jurisdiction. I'm not saying that he doesn't have jurisdiction, but he lacks the jurisdiction because he could not have filed this limitation. He could not have taken the benefit limitation on suppression of facts, because suppression of facts, he has to justify that it is burden of the department. There is not a single only stating that there is suppression of facts. But this income tax, how I have suppressed? Otherwise, why the department accepted the VAT of 9 crores 21 lakhs? We made the department VAT also as a party. Why they have accepted? They said, no, we are not accepting it. All these returns were before the, otherwise how they will come? They have come to know only from my income tax return and SR3. Only they have come to know. Service tax I paid 31 crores, 9 crores I evaded because I should have paid the service tax. This is what they are saying, my lord. Evasion of tax. Now, if your lordship kindly see on the second point, like the jurisdiction point, if you take the act, kindly take the act, my lord. That is Service Tax Act, Chapter 5 of the Finance Act 1994. It was. We have given a copy. Lordship got it? See kindly, my lord, 73. 16 page, below 16, bottom 16. Recovery of service tax, not levied or paid, or short levied, or short paid, or erroneously refunded. Where any service tax has not been levied or paid, or has been short levied or short paid, erroneously refunded, Central Excise Officer may, within 30 months from the relevant date, service notice on the person chargeable with service tax, which has not been levied or paid, or which has been short levied or short paid, or the person to whom such tax refund has erroneously been made, requiring him to show cause as to why he should not pay the amount specified notice. So this 30 months, within 30 months, the demand notice, my lord, a demand notice has to be served from the financial year. Now, provided that where any service tax has not been levied or paid, or has been short levied or short paid, or erroneously refunded by reason of A, fraud, B, collusion, C, willful misstatement, D, suppression of facts, or contravention of any provision of a chapter or of the rules made thereunder, with intent to evade payment of service tax, the person chargeable with the service tax or his agent, the provision of this subsection shall here have effect, as if for the words 30 months, the word 5 years have been substituted. So there are two situations, 30 months and proviso to the department. Now, my lord will kindly say 73.6. What is relevant date? At page 18. page 18, relevant date, 6, 73(6). For the purposes of this section, relevant date means in case of taxable service in respect of which service tax has not been levied or paid or has been short levied or short paid A. This is we fall A, where under the rules made under the chapter, a periodical return showing particular service tax paid during the period to which the said returns relate is to be filed by an assessee, date on which such return is so filed. So 2015-16, my lord, that is the period which, my lord, the income tax and the SR3 was filed. And they found from that out of 40 crores, 31 crores has been paid, rest has not been paid. Rest we paid as a VAT. Now, the second point of jurisdiction point, my lord, it is the authority who has to, it is their case that there is, my lord, suppression of facts. It has to be established by them prima facie. Prima facie, it has to be established. Then the question of, my lord, suppression of facts will come. Otherwise, you are taking the help of proviso, which you ought to have taken the 30 months. 30 months, you know.
No, why not this issue cannot be within the province and ambit of the appellate tribunal?
No, then there are two things which I first argued.
Because jurisdiction is there. Now, how he has exercised the jurisdiction
yes.
on the facts of the case is within the ambit of the appellate tribunal.
But my lord, these are
Absolutely, there is jurisdiction.
But he doesn't decide on the principle of natural justice also, my lord.
But region he has assigned.
No reasons, what reason? My that reasons.
No, there is a reason.
Let us see, my lord.
Absolutely, yes, there is a reason.
Reason.
What reason he has, whether that is acceptable or not, that can be
No, what
decided by the.
My lord, I am not.
Yes, there is. There is.
So not only on the judgment. If judgment is likely to be looked by your lordship, then your lordship, of course, then remedy goes before the tribunal.
No, we are not discussing the.
We are only on the principle
Let
of
us see
natural
the
justice.
region. Let us see the region.
Yes.
Order in original.
Yes. This starts from page 91. And 95. 95.
No. Order in original.
Page original, 47. 47.
He has dealt with the issue at page 59, 4.6.
A starting point of page 48, my lord, 1.1, which he, I think, not discussed. 4.1.11. That's the 1.1. 1.11 brief facts of the case, 1.11 at page 55.
Yes.
Yes. Kindly see my note. 1.1 answer. Notice was asked to submit. Sir, last part, 3 lines. Notice was asked to submit certain document by letter dated for asserting his actual service tax liability during the financial year. But the notice he failed to submit the same.
Okay,
On
that
yes,
is why, whether it is statutorily obligated, that
yes,
is what I am asking.
yes,
Whether this notice,
yes,
49/2000, this kind of notice,
yes.
the respondents are under statutory obligation to issue.
I understand, my lord.
That is the issue.
Yes, I got your point.
Because in other case, like other one, like your case, this court has granted stay.
Hmm.
Right? Because it was statutorily obligated.
We-
And
we-
that was not done by the authorities. I found that
Your-
prima facie,
Right.
I found that yes, they are under statutory obligation to issue such kind of notice. If an act is to be done in a particular manner, that act is to be done in that particular manner. Right? So on that count, I have
Right,
considered the issue.
right.
But here, that is why I am asking the question that whether this 49/2020 notice, this kind of notice, they are under statutory obligation
I understand.
to
I
issue.
understand the point, what your lordship said.
Because otherwise, this can be gone into by the appellate tribunal. We are into re-jurisdiction. So if they are under statutory obligation to issue and plus serve as such kind of notice, because your plea is that you have not received,
Yes,
right? That is what that issue is I am examining.
right, correct.
Am I clear?
No, I got the point. I got
So
the
this
point.
is the issue.
No, I got the point. I got the point.
So even if
But what your lordship is saying, whether statutorily under the statute, it is a mandatory on their part to issue a notice on dated 4/9/2020.
because in some
If
other
it
kind of
prescribes,
notice,
if it prescribes, then the manner they have to do it because this act provides. If it doesn't do it, that's the end of the matter. Then High Court-
because in the other case, once a so-called notice is issued, a prima facie opinion is formed that yes, he has violated certain provisions of law.
Correct.
And in that particular case, it was prior to issuance of so-called notice, it is statutorily prescribed that please explain this. Explain this. Then if explanation is satisfactory, he will drop, or otherwise he will again issue a particular form.
So why
Right. That is what I am
I
asking
understand.
repeatedly.
I understand your particular, the mind of the court. Okay, your lordship want to know that if his territorially is mandatory for serving this notice under the dated 4/9/2020,
And
and
to-
they have not done it, then it amounts to a principle of natural justice.
That may be because in that at that time, prima facie opinion is not formed. You were asked to SSC was asked to furnish certain documents so that he can decide the issue. But once demand comes, show cause notice means the prima facie opinion is formed. Am I clear?
Yes.
And thereafter, personal hearing, reply, all these were there. That facets of natural justice is complied with. But whether this is under statutory obligation there, this kind of notice, that is the issue. Otherwise, we have to deal with
Otherwise, I will.
by settled provisions of law.
My lord, this is what my learned friend are showing to me, that there are some circular which are issued, these are mandatory in nature. I have to see it myself, my lord. I can't say in 1 second I cannot read and
Right.
something. These are very important issues where your lordship decides this issue. Now today, if your lordship finds that statutory, there is no provision as such of such type of notice of 4/9/2020, then the question will come, whether even then whether principle of natural justice has to be followed. This is one. Even if these are not there, that
If they were being more benevolent and yes, before issuing the so-called notice, let us
but
have a notice served.
My lord,
That will not
I-
be violation of principle of natural justice under the statutory provisions. This is my tentative view.
no, it's okay, fine, my lord. We understand. If views are there, then we can look into it, my lord.
Because we have to see what kind of, to what extent the principles of natural justice have been violated. That is one. And what kind of jurisdiction.
But then also your lordship's query was that there is an absolute principle of natural violation. That means, my lord, no notice, nothing was served, and you have not been heard. This is absolute principle of violation. Whether second part, which I am coming before this court, which I came, is on the part of the during the course of deliberation, before hearing, whether that opportunity should be given, also that can be treated as a part of principle of natural justice. So this I will try to. But what is more important is about the statute, whether this type of notice are mandatory required or not. Well, if it is required, then end on the matter, my lord.
If
I
notice was
feel-
not served,
Yes, and which is mandatorily, it is required under the statute.
because your plea is that it hasn't been served, but that is whether that, the question goes like this, that whether this kind of notice was statutorily required to be issued and served. Otherwise,
My lord, my lord, your
that
lordship,
is,
let me
if they
just
have become more transparent, that does not make it a case of violation of natural justice.
I will just go through this provision. Your lordship
Otherwise,
indicate-
in the other case, as we have passed an order, this is not a kind of that pre-demand come show cause notice. There is nothing contemplated in the statutory provisions of chapter
Fine.
that there should be
Yes.
prior intimation. In the other case, under GST, we found that there should be there are stages. Thereafter, one is to be issued the show cause notice. That principle, Nazir Ahmed is still holding the field. That is what my
Yes.
tentative view is. Because all these judgments says that if something is required to be done, it is must be done. Without it, it fails. That is why,
No, no.
otherwise, the trigger point is the demand comes from show cause notice.
My lord, when I file also, I know my limitation to what extent, my lord, the High Court your lordship can look at it under 226. Because I said, on the opening, I said that there is a
Yes.
provision for tribunal.
No, out of these four, right from Whirlpool or
Yes, so
Harbansal,
Harbans, yes.
only
Subsequent
two
also.
grounds you have urged. One is violation of principle of natural justice. Second is jurisdiction.
But more important, your lordship, on 4/9/2020, if that statute doesn't provide, statute provides, then situation
That
will be of
out
course
of
different.
because I am not very much.
So, my lord, because in the Finance Act, I think there is no such provision in the Finance Act. But there is a circular which my learned friend is saying that they have issued. Now they have filed with that these are mandatory. But of course, let me go through it and place it before the court. Because in absence of any provision under the Act, if there is a circular which has been issued and which makes this particular makes a mandatory, of course, my lord, it should not be like my lord overlapping the provision of the statute.
So,
My
What
lord,
do you-
what I will do it, my lord, your lordship can fix it on Tuesday is a hearing day. In the meantime, my lord, I will look into this aspect of the matter and I will inform the court.
Mr. Kyle, how it was served? Do you have any idea?
Through email notes.
Huh?
The first page notes.
Is this the email?
Yes, sir.
Hmm?
Lots.
Sender is okay, but whether this
Yeah, this is a-
receiver is correct?
Is the representative of the petitioner.
Okay.
He appeared before the authority law. Before the assessing.
This is another letter, not 4-9.
4-9 is, that is provided, yes. I'll make inquiry.
You heard Mr. Didas, senior counsel assisted by Mr. Imam. And SC Kyle, standing counsel, GST, further as per number 1 to 3.
2, 3, and 4. One, the central government council is
Okay, MS.
Me, P. Tamuli on behalf of Miss Kepcon.
Kepukon. Learned counsel for as per number 1. And Mr. SC Kyle, learned standing counsel, GST, further as per number 2 and 3. Okay. On the as
Ninth.
sought for by Mr. Das, senior counsel for the petitioner. Place the case on Tuesday, next month. 9-1. Till the next date of the thing. Yeah, I got to repeat, but there shall not be any course of action pursuant to the order in appeal dated 21/9/2023.
Much of it.
Deeply aware. Hello.
Item number 4 for admission.
Yes. Subroto Ghosh.
Regarding Malaka cell date Malak
Let us see. I have forgotten everything. All these are factual things.
Malaka
Subroto Ghosh. Okay.
Subroto Ghosh is the father of our
1 minute.
Malak.
Let me read it.
Malak.
Santosh Kumar Ghosh. Where is the mutation order?
Mutation order Malak, kindly see Malak. Page 23, my lord.
Page 23. Where is the vernacular?
Vernacular, my lord. Page 24, my lord. Initially, my
What
lord,
is the area of the land?
my lord, the area of the land, my lord, 1 kotha 12 place, my lord. Covered by DAG number 1977/978, periodic kotha number 9. Mutation order passed on 17/5/2005 in the name of the father of the petitioner, Santosh Kumar Ghosh. Thereafter, my lord, the father of the petitioner died in the year 2020. Page 25, death certificate. And
So, according to you, Ratan Kumar Ghosh, Subhas Chandra Ghosh,
and
and Santosh Kumar Ghosh,
my lord,
their names were mutated
my lord,
on 17/5/2005.
5,
And Santosh Kumar Ghosh was your father.
father. Kindly see page 28, my lord, impugned order,
We'll see,
my lord.
Your father died?
Died in the year 2020, my lord. Death certificate, my lord, page 25. 22 to 2020.
Where is that 1/11/2021
Page
order?
20, page 28, my lord. And it reflected in the Jamabandi committee.
Which part, which page?
Page
Jamabandi.
Jamabandi, my lord,
Where is Montos Kumar Ghosh?
page 45, my lord. Panas, lord.
No, vernacular.
Page
Page?
45.
In the list. That is the entry in the list.
Yes. Empty in the
Left hand side,
left hand side, my lord. Page 45.
Page 35.
45, my lord. Page 45.
35 Montos. Serial number 81.
81. And the remark column, my lord, page 45.
Come to remark column. But Santosh Kumar Ghosh was also there.
There, my lord. Subsequently, my lord, his name was deleted. And
Let
in
us
place
see,
of
and where is the entry? Page.
page 45. Third paragraph. Latmandal Arup Kumar Nath dated শ্রী সন্তোষ কুমার ঘোষ মৃত স্বর্ণদা ঘোষ নাম সংশোধন কৰি শ্রী মন্তোষ কুমার ঘোষ কৰা হল। লাটমন্ডল প্ৰতিবেদন চল সংশোধিত বাবে অনুমোদন দিয়া হল চক্ৰবৰ্তীয় dated 2021-11-1 After knowing it that I filed representation before circle officer. Page 47. And thereafter also Malab filed a representation before the deputy commissioner. Page 49.
No, when you submitted before the circle officer?
Representation
10/6/2022.
Malab 22.
What he did?
Malab
Let us see the.
thereafter Malab during
Let us see the affidavit.
affidavit my lord and list my lord. Page 84 my lord. Order was passed my lord.
1 minute. What is his stand?
10 minute my lord.
Let us see his affidavit.
Paragraph 8.
Montos Ghosh submitted an application.
From paragraph 7, last part.
For correction or a name of the median and state application was presented, right?
It is an inadvertent mistake on the part of the deponent that no notice was issued to them prior to passing of the correction order dated 1/11/21. Is admitted, my lord, that no notice was served. The correction was given effect on the basis of the certificate copy of the sale submitted by Montos Kumar Ghosh.
Your application was 10/6/2022 was disposed of.
Disposed of.
The hearing was conducted. Sorry. Rotkan Subhas Santos. And Mont. ওই কাগজ এখন দিয়েছেন You are Mr. Subrata.
Son of Santosh Kumar Ghosh.
You are also not in possession of the land.
But Montosh Kumar Ghosh no, also not in possession of the land, but it possessed by someone, my lord. Himself admitted that no notice was served prior to issue of the impugned order, my lord.
Have you made Montrose a party here?
No, my lord. Because, my lord, at that during period, I seeking relief from the circle officer, my lord. That's why, my lord. And subsequently, my lord, that order was passed, my lord, by the circle officer.
Yes, I'm going to tell me.
Yes, our stand is,
Yes. What is the law?
our stand
What is
is,
the procedure? Your stand is refer to competent authority. So what is the competent authority? Or what is the competent court? What issue is to be decided now?
here it is said in paragraph 8, page number
Refer to competent
70.
court authority for redressal of the dispute.
My lord.
Yes,
What do you say?
the competent authority passed this order, Lordship.
Competent authority?
Circle officer passed the order.
Firstly, he passed the mutation order
Yes,
without issuing any notice to the other parties.
yes,
Subsequently.
He effected the mutation
Yeah.
in 2005.
Yeah.
Then petitioner said that, see, my father's name was deleted without issuing any kind of notice to me.
Mm.
Then he proceeded with this proceeding.
Yes.
and did not decide anything.
Yes.
Right? Whether he has the power to decide after passing an order, second thing. To which authority he is referring that go after committing the mistake himself. He has said, is it not?
Yes.
Inadvertent mistake.
My lord,
Paragraph
7,
7,
last portion.
last 5 line.
Yes.
Fifth line from bottom.
Yes. It is in
Right.
mistake on the part of the
After committing the mistake himself, not correcting the mistake himself, he is referring the parties. Go to somewhere else. Tell me where they should go.
revenue board.
Revenue board.
It is not a mutation order, my lord. It is a correction order, my lord. Subsequently corrected.
Hmm?
I also filed representative before the deputy commissioner. He is the my lord, higher authority, my lord. Next higher authority, my lord. That representative also pending, my lord. Honorable may direct the deputy commissioner to dispose the representation, my lord, or decide the issue, my lord.
Kindly see the order, Lordship. 80 page 85 of our epidemic.
Page 55.
85.
85.
Yes. Running page 85. Quote from fourth line. Subsequent to the hearing on 13/1/2022, 2022, another hearing was conducted on 12/5/23 involving the first party Subrata Kumar Ghosh and the second party Montos Kumar Ghosh, son of so-and-so, Subhas Kumar Ghosh, son of late Swarnananda, Ajay Kumar Gop, son of late Ratna Kumar Gop. During the hearing, two allied co-purchaser, namely Subhas Kumar Gop and Montos Kumar Ghosh, were present. During the hearing, Montos Kumar Ghosh produced the original registered sale deed number 1230 dated so-and-so. During the hearing, Montos Kumar Ghosh claimed the plot of land based on the possession by him on the land and the original registered sale deed which is also in his possession. The first party could not produce any document in support of his claim. He also acknowledged that he is not in possession of the land.
No, MS Uro, illegality was done by him on an earlier date.
111.
After admission of illegality, he should have cured the illegality. Going here and there thereafter. First, he has to examine whether his earlier order was correct or not. Tell me on the basis of Assam Land and Revenue Regulation, his earlier order was correct or not correct? As a state council. Yes, MS Bordele. You are the author of this. You are the author of this. Or you have to support these provisions. So how you defend that earlier order? Changing name from Santos to Montos. But Mr. Pangiri,
my lord.
in absence of
Montos,
Montos,
my lord.
we cannot also set aside
Then,
the earlier order. That is a difficulty.
look, I may be permitted to implement, my lord,
No, at this stage, after
1 year.
you are a seasoned council, knowing fully well you have stipulated, will decide to pass the order. Okay. We'll come back and pass the order. The instant petition under Article 226 of the Constitution of India. Now, is preferred by the petition seeking inter alia direction to the respondent authorities, comma, more particularly, comma, the respondent number 3 and the respondent number 4 to take necessary steps for cancellation of a mutation order dated 1/11/2021, passed by the respondent number 4, whereby the name of the petitioner's father, BIPIJ, Santosh Kumar Ghosh, alias SNTOSH Kumar Ghosh, alias SONTOSH Kumar Gop, had been deleted from the in respect of a plot of land measuring 1 kasa 12 places. The case projected in the writ petition can be stated, comma, in brief, comma, as follows. The petitioners, the petitioner's father, namely Santosh Kumar Ghosh, alias Santosh Kumar Gop, along with his two brothers, namely one, Ratan Kumar Gop, and two, Subhas Kumar Gop, had purchased a plot of land measuring 1 katha, 12 acres, covered by tag number 977, 978, and patta number 9, situate at Sorbuk town, Mauja, Domoka, Sokobausi, Bornagar Revenue Circle, within bracket the subject for from 1 Santabala Puri, there are two আছে, huh? Alias Santabala Puri, same thing, Santibala Puri, alias Santabala Puri, and 8 others, while a registered sale deed number 1230 dated 19/9/2081.
1981.
Subsequent to the purchase, and an application being made for registration within bracket mutation, the respondent number 4, i.e. the circle officer, Bornagar Revenue Circle, Sorbuk, passed an order on 17/5/2005, mutating the names of Santos Kumar Paul alias so 1, 2,
Ratan
Ratan Kumar Ghosh, and 3, Subhas Kumar Ghosh, all sons of Swarnada Soran Ghosh, in respect of the subject plot. It is the case of the petitioner that the petitioner's family, the father of the petitioner, and the family was in continuous possession of the subject plot subsequent to the purchase and the mutation order dated 17/5/2005. On 22/02/2020, the petitioner's father expired leaving behind two sons and one daughter. That is Subrata Ghosh, within bracket the petitioner, Roman 2, Srimati Sangamitra Ghosh, within bracket the daughter, and he died also, leaving behind a petitioner and a daughter. Full stop. Another son of Santosh Kumar Ghosh, VIJ Sujit Kumar Ghosh, had expired, had also expired. Full stop. Yeah. It is a further case of the petitioner that after the date of the petitioner's father, one of the uncles of the petitioner namely Montos Kumar Ghosh, had made attempts to dispossess the petitioner's family from the subject plot. Full stop. In view of such attempts, the petitioners made an inquiry in the concerned office and full stop. During such inquiry, it came to the knowledge of the petitioner that the petitioner's uncle, Montos Kumar Ghosh, had inserted his name in respect of the subject plot. Full stop. On further inquiry, the petitioner, it came to the knowledge of the petitioner that the name of the petitioner's uncle, Montos Kumar Ghosh, stood inserted in the revenue records in respect of the subject plot pursuant to a mutation order dated 1/11/2021 passed by the respondent number 4. নতুন প্যাড এখানে সাবপ্যাড হবে having got the knowledge about insertion of the name of Montos Kumar Ghosh in place of his father, that is Santosh Kumar Ghosh, the petitioner made an application before the respondent number 4 on 10/6/2022 seeking correction in our revenue records for the subject plot by way of deletion of the name of Montos Kumar Ghosh and insertion of his father. So by the said application, petitioner sought for a restoration of the original mutation order dated 17/5/2005. The said application, on receipt of the said application, the respondent for registered the same as petition number 77/2021-2022. From the case records, it transpires that it has emerged that from the case records as well as from the affidavit in opposition filed by the respondent number 4, it has emerged that after registration of petition number 77/2021-2022, the respondent for issued notices to the petitioner as well as to the other 3 stakeholders, that is Subhash Chandra Ghosh, to Ratan Ghosh, Subhash Ghosh, Ratan Ghosh, and 3 Montos Ghosh. Stop. As Ratan Ghosh had expired, in the meantime, he was represented by his son, Sri Ajoy Ghosh, in the proceedings before the respondent number 4. The proceedings initiated by respondent number 4, right, petition number 77 stroke 2021, that's 2020. So Savita's further emerged that the respondent number 4 conducted hearings on
Two occasion, my lord. Initially,
2 occasions, that is
13.
on 13/1/2022 and on 12/5/2023. Full stop. The respondent number 4 during the said hearings heard the parties full stop. Heard the parties, including the petitioner and the representative of Montos Kumar Ghosh. Full stop. In the course of the said hearings, the original registered sale deed number 1230 dated 1981 was produced before the respondent number 4. Full stop. After holding the hearings, the respondent number 4 in his order dated 12/5/2023 had observed that on the basis of the original registered sale deed and after hearing the parties, he could not come to a conclusion as regards the rightful owner of the subject plot. So as he could not come to a conclusion as to whether Santosh Kumar Ghosh or Montos Kumar Ghosh was the rightful owner of the subject plot, the respondent number 4 decided to advise the parties to approach the competent court stroke authority for redressal of the dispute as regards the rightful owner of the subject land. Full stop. By the order dated 12/5/2023, the respondent number 4 has further observed that till any decision as regards the rightful owner of the subject lot, the order dated 1/11/2021, whereby the name of Santosh Kumar Ghosh was deleted and the name of Santosh Kumar Ghosh was inserted, would be kept in abeyance. In view of the aforementioned sequence of events, uh, the order dated 1/11, petition order dated 1/11/2021 has been kept in abeyance. From a perusal of the mutation order dated 17/5/2005, it transpires that the said order was passed in connection with mutation case number 95/2003-2004. Mutation order passed by the circle officer. Respondent number 4, that is circle officer.
Gornagar Revenue Service.
Board of Receipt. The names of Ratan Kumar Ghosh, Subhash Chandra Ghosh, and Santosh Kumar Ghosh, within bracket the petitioner's father, all sons of Swarnada Ghosh, were mutated in respect of the subject lot in place of its erstwhile owners on the basis of purchase and possession. From the affidavit in opposition of the respondent number 4, the respondent number 4 in the affidavit in opposition has stated that an application registered as application number 173 was submitted by Santosh Kumar Ghosh on 27/9/2021 at his office, along with a certified copy of the registered sale deed dated certified copy dated 22/9/2021 of the register sale date dated 19/9/1981 and was by the said application, Montos Kumar Ghosh, alias Gop, alias Gop করে দিব Gop লিখিতে পারবেন Ghosh লিখি alias Gop করে দিব হ্যাঁ short correction in a mutation order dated 17/5/2005 by insertion of his name in place of Santosh Kumar Ghosh. The response number 4 has further stated that in the certified copy of the registered sale date, the names of Ratan Kumar Ghosh alias Gop and Subhas Chandra Gop alias Ghosh alias Gop were found mentioned, but it did not issue any notice to those persons prior to passing of the order dated 1/11/2021. Full stop. The response number 4 has further stated that the insertion of the name of Montos Kumar Ghosh alias Gop and deletion of the name of Santosh Kumar Ghosh alias Gop was given effect to on the basis of the certified copy of the registered sale date submitted by Montos Kumar Ghosh alias Gop. It is also seen, it is also noticed that alleging the alleging about the irregular manner by which the order dated 1/11/2021 was passed by the response number 4. The petitioner submitted an application for cancellation of said order also before the Deputy Commissioner Borpeta, within bracket, the response number 3. And the said application was duly received and the receipt of the said application was duly acknowledged by the office of the response number 3 under seal and signature. Under seal and signature 38/2020. Chapter Roman 4. Part B. Colon registration of the Assam Land and Revenue Regulation, 1886. Has provided for the procedure for effecting registration within bracket mutation. As per section 50 thereof, comma, it has been provided inter alia in section 50 thereof, to the effect that every proprietor or landholder succeeding to any estate, comma, or share in an estate, comma, whether by transfer or inheritance, comma, and obtaining possession of the same, shall have to apply to the deputy commissioner, jurisdictional deputy commissioner, on the general registers of which the estate is born, for registration of his name as such proprietor, comma, landholder, as such proprietor or landholder, and of the nature and extent of the interest in respect of which the application is made. Section 52 has laid down the procedure for registration on application. As per it has been prescribed that on receiving an application for registration, comma, the deputy commissioner shall, comma, if he considers that there are sufficient grounds for proceeding with the application, comma, publish a notice requiring all persons who object to the registration of the name of the applicant, comma, or who dispute the nature or extent of interest in respect of which registration within bracket mutation, registration within bracket mutation is applied, have in a written statement of their objections, comma, appear on a day to be specified in a notice, not being less than 1 month from the date thereof. It has been further provided that if the application alleges that the applicant has acquired possession of the estate, comma, or share in an estate, in respect of which he applies to be registered by transfer from any person, comma, a copy of the notice shall be served on the alleged transferor, comma, if he is dead, comma, upon his heirs. As per section 53, comma, on the day fixed in a notice issued under section 52 or as soon thereafter as possible, comma, the deputy commissioner shall consider any objection which may be advanced, comma, and after such further inquiry, within bracket, if any, as appears necessary to ascertain the truth of the succession, comma, assumption of charge or position, alleged in the application, comma, shall, comma, if it appears to him that the succession accompanied by position has taken place, or that charge has been assumed, or that the applicant is in position, comma, as the case may be, comma, make an order directing the registration stroke mutation. Where? From the statement made by the respondent number 4 in the affidavit of opposition filed by him, it has clearly emerged that before passing the order dated 1/11/2021, no notices were issued to any of the persons and for the purpose for the case in hand, comma, one Santosh Kumar Ghosh, alias Gop, two Ratan Kumar Ghosh, alias Gop, and Subhash Chandra Gop, Ghosh, alias Gop, prior to passing of the order dated 1/11/2021. As the names of Santosh Kumar Ghosh, Ratan Kumar Ghosh, and Subhash Kumar Ghosh were inserted in the revenue records in respect of the subject lot by the mutation order dated
17.5.
Hmm?
17.5.
17/5/2025, comma,
2005.
2005. They are clearly the persons who were likely to object to the registration or mutation of the name of the applicant therein, that is Montosh Kumar Ghosh. Since the petitioner has not implemented Montosh Kumar Ghosh as a party respondent in the instant petition, comma, it is settled provision of law that in a writ petition, comma, and any order adverse to any order which is likely to be prejudicial to any person cannot be passed in his absence. Full stop. person who is likely to be visited with adverse consequences is to be implicated as a is to be necessarily implicated as a party respondent. Since in the instant petition command, the petitioner has not implicated Montes Kumar Ghosh as a party respondent, no order regarding this court is of the considered view that no order regarding the validity, legality and validity of the order dated 1/11/2021 passed by the respondent number 4 can be this court is of the opinion considered view that it would not be proper to pass any order as regards the legality and validity or otherwise of the order dated 1/11/2021 passed by the respondent number 4 as in the absence of the applicant at whose behest, in the absence of the applicant, on the basis of whose application, the order dated 1/11/2021 came to be passed. Para. Section 151 of the Assam Land and Revenue Regulation 1886 reads as under quote করে দিব। নোট করে দিবি হ্যাঁ তাতে নোটটা আসবে সেকশন 151 From the note appended to section 151, it transpires that an order once passed in any case cannot be revised either by the officer who passed it or by his successor in office. But the deputy commissioner has been vested with the authority and jurisdiction to call for the proceedings held by any officer subordinate to him and pass such orders thereon as he thinks fit. As against the order dated 1/11/2021, the petitioner has already submitted an application
Is 49.
before the respondent number 3, before the jurisdictional deputy commissioner, that is the respondent number 3,
Is
on
30.
30/8/2022, and the said application and the receipt of the said application was duly acknowledged by his office under seal and signature on 30/8/2022. And the same has not yet been and it has been projected and it has been asserted by the petitioner that the said application has not yet been disposed of. This court is of the considered view that the jurisdiction deputy commissioner, that is the respond number 3, shall take the application, said application on board to consider the legality and validity of the order dated 1/11/2021. Passed by the respond number 4 by taking into purview provisions regarding registration within bracket mutation contained in the Assam Land and Revenue Regulation, and to pass a speaking order thereafter. This court is also of the further view that before passing any speaking order on the said application, the respond number 3 should afford reasonable opportunities of hearing to all the stakeholders, all the persons who are likely to be affected either in the event of affirming or reversing the order dated 1/11/2021. And for that purpose, those persons should be issued, should be duly served with notices for such personal hearings. For the purpose of facilitating the respond number 3 to proceed with the application, to proceed with the application and for disposal, the petitioner shall submit a certified copy of this order at his office within a period of 3 weeks from today. Full stop. In addition, in addition, a copy of each, a copy of the order shall also be furnished to MAS Borua, Lana Junior Government Advocate Assam, for the purpose of informing the respond number 3 from her end. I would like to go. I have heard Mr. A.R. Patgiri, counsel for the petitioner, and Boduloi, standing counsel, Revenue and Disaster Management Department, for the respond number 1. Respond number 2 is abolished.
abolished.
abolished now, my lord.
And Mr. M.S. Burwal and Council for the respond number 3 and 4. Full stop. It is submitted by the land, it has been submitted by the land council for the parties that office of the commissioner, office of the the office of the commissioner, Lower Assam Division, Guwahati, within bracket the respond number 2, has since been abolished by the state government. Yes, any other incorporation? This order, disposal of the repetition.
Within a period of, my lord. Entire exercise.
Full stop. It is observed that the respond number 3 shall, it is expected that the respond number 3 shall make endeavor to complete the exercise as expeditiously as possible, preferably within a period of 3 months from the date of submission of the certified copy of the order by the petitioner at his office.
My lord. Obliged.
I have a small prayer in the case, my lord. Since the representation already been submitted to the deputy commissioner, my lord, to consider my case, my lord, since the subdivisional level advisory board, advisory committee, my lord, they approve my this proposal for settlement of the land, my lord, 8 acres of land at Silavathar town, my lord. And my lord, since the father of the petitioner was in possession, subsequently, since 86, my lord, the petitioner is in possession, my lord. That part already been enlightened, my lord. Lordship will find that is.
Tell me firstly, what is the prayer?
My lord, only, my lord, since the matter is pending before the deputy commissioner, my lord. Earlier occasion, my lord, it was sent to the government. And government has said that since the value of the land is has to be.
There could be 2 kind of disposal. One is simply to consider the petition 25/11/2022 filed by the petitioner by the deputy commissioner. That is your prayer number 1. Or for this court to enter into merit. Yes, Mr. Burwa. Which kind of?
The shortest possible way.
No, that is why I am asking. If I enter into merit, I will make observation.
Yes.
And if you think that I should not enter into merit, then I will simply
Ask to dispose of.
direction simplicity to consider in accordance with law.
Yes, that would be.
Choose either of the 2 options.
No, since matter is a SDLS.
There cannot be 2 proceedings there, right? 2 parallel proceedings. If I enter into merit, it may either yes or no.
Yeah.
Am I clear? I may reject your petition, then end of the matter.
Yeah.
There will not be settlement. There will be only writ appeal and SLP. Or otherwise, if you want disposal, only that direction to the deputy commissioner to consider your representation and to dispose of the representation in accordance with law.
Yes.
Then I'll pass that on.
Lordship.
Then you will have the opportunity to come back again.
Yes. They will get another.
Choose
Yes.
A or B.
A.
Merit.
No.
Since
representation, my lord, since it is a regarding consideration of representation, since matter is pending for long time in the office of the deputy commissioner, my lord, and whatever grievances I had, my lord, that has been already placed. And my lord, only the one point I would like to say, since the proposal was sent to the government, my lord, in 2008. And the government has said that, yes, only valuation has to be increased. That has been already been sent in 2015. And 2018, the deputy commissioner also said that already proposal has been sent.
This disposal is, this is under 151. This is not under, cannot be on under 151.
No, since any documents, if anything is there, then that.
No, he can call for the proceedings of
Yes. Yes.
under, this is, your case is for settlement.
Yes, settlement. That
That
appeal
is-
is there, my lord.
Hmm?
That appeal is there, my lord. Lordship will find at page 36,
Tell me what is your story then.
lordship.
Tell me what so you want disposal of the representation.
Lordship.
Okay, let us find out what are the facts.
Yes. Facts, my lord.
What is just land?
Land, 8 ledgers of land, my lord. Lordship,
8 lesser of land.
Lordship will find the proposal, my lord, at page 28, my lord.
We will not go into that for disposal.
Yes.
Or just under description. Okay.
Just to understand, my lord. This proposal was given by the Deputy Commissioner to the Secretary of Government of Assam. That is on 17th December 2008. Settlement of land with Matram Sutia. With reference to the subject, may I read, my lord? It will be better, my lord. With reference to the subject cited above, I have the honor to inform you that a proposal for settlement of land with Matram Sutia, son of Balaram Sutia, has been received from the circle officer, Shishiburga White, his letter number so and so, 19/4/2007, for a plot of land measuring 8 ledgers land, my lord. Only covered by Dag number 199 of Ward number 2 of Silavathar town, which falls within the radius of 3 kilometers of the Silavathar town. The proposal has been approved by the district authority for placing in the SDLSC meeting, and accordingly, the SDLSC meeting held on 30/10/2008 has approved it at Annexure 4 at serial number 9. The list of the minutes of the meeting includes the proposed land is first-class business land and used as a business purpose. The applicant belongs to MOBC Chutia caste and is married person, and his occupation is business. His name is included in the Chitha copy of the proposal. The present market value of the land per hectare area has been fixed at so and so, 3 years registered, so and so rupees. Lastly, it is given 4 lakhs per bigha. Only per hectare oblique area land, and accordingly the value of the proposed land will be rupees 32,000 only, as revealed by the report of Circle Officer Shishiburgaon Revenue Circle. Therefore, necessary records are enclosed herewith for favor of kind information necessary action. This is the approval. Now, the Deputy Secretary has sent a letter, my lord, to the Deputy Secretary wrote a letter to the Deputy Commissioner. I'm directed to, that is next page, my lord, 29. I'm directed to refer to the letter on the subject cited above and to request you kindly to submit the update valuation as per zonal valuation. Update valuation, my lord. Now, as per the this circle officer's letter, the ADC has wrote a letter to the circle officer on 23rd July 14. Then the circle officer has submitted a letter, my lord. Next page 31. To the Deputy Commissioner Dhamra District regarding settlement of land in the name of Matram Sutia. Your letter number so and so, sir. With reference to the subject cited above, it is hereby informed you that with regard to proposal for settlement of the land measuring 0 biga 0 katha 8 ledgers of Silavathar town block map under Dag number 199, beg to state that the land value as allotted by the Dhamra District Advisory Committee as per their letter number so and so 28/7/2011 per biga land value is rupees 6 lakhs, and hence for 0 biga 0 katha 8 ledgers land value would be rupees 48,000. This is land value. That has been after 6 years, this land value has been increased.
This letter of 2008, the basis on which you are seeking settlement can be referred to. Thereafter, communication exchanged
Yes.
between the authorities regarding valuation of the said subject lot. Then ultimately,
In 2018, Lordship, that pays
it
35.
it continued regarding valuation up to 2015,
Yes.
right?
Then in 18, my
Then
lord,
18 again, some resubmission.
resubmission of with
proposal,
new
right?
checklist.
But the matter
That has
has
also
not matter of settlement has not been brought to its logical conclusion.
that
right?
that's
So in view of such stalemate,
Lordship.
the petitioner at this stage has prayed for a direction to
Direction, my
the deputy commissioner
to consider.
to bring the matter of settlement in respect of a spot measuring so and so.
Yes.
In favor of the petitioner to its logic and conclusion after considering the merits of the claim of the petitioner in accordance with law and as per the land policy.
Within the time
Yes.
period, my lord.
Yes. Within defined period, that's all.
That's
Okay, we'll come back. Will declare anything
Okay.
within defined period?
Yes. Yes.
In fact, at two, might be replaced by some other council.
You be there, why?
I have some personal.
Deputy Commissioner. That is on an application being made for settlement of the said subject land in favor of the petitioner, the jurisdiction deputy commissioner, that is the deputy commissioner Dhemaji, by a communication bearing number is 28 DRS 42/2007/20 dated 17/12/2008.
Yes.
Bearing communication number so and so on the subject dash settlement of land dated 17. Submitted a proposal for settlement of subject land before the revenue within bracket settlement department, government of Assam. Full stop. In the said proposal, Deputy Commissioner Dhemaji, respond number 2 for your bracket. The respond number 2 had conveyed that a proposal for settlement of the subject land in favor of the petitioner was received from the circle officer, CC Bogar Revenue Circle within bracket the respond number 3 provide a letter dated 19/4/2007. Stop. It was further conveyed that the proposal was approved by the district authority for placing it before the subdivisional or subdivision.
Subdivisional land advisory.
Where is that proposal? Subdivision anything? Yes.
It is not there, my lord. Only
Subdivisional level
yes.
advisory committee
Yes.
within bracket SDLAC. And thus SDLAC in its meeting, held on 30/10/2008, had approved had accorded its approval. Full stop. By the said communication dated 17/12/2008. It was further informed that the subject land falls in the category of first class business land and was to be used for business purpose. Full stop. As regards the petitioner, comma, it was mentioned that he belongs to MOBC within bracket Chutia, and his name is included in the CETA copy of the proposal. Subsequent to submission of the proposal on 17/12/2008, communications were exchanged among the Revenue Settlement Department, comma, the Deputy Commissioner Hemaji, and the Circle Officer Sisiborgaon Revenue Circle. In the subsequent period from the date of submission of the proposal till in the subsequent period regarding the valuation of the concerned subject land. Also. On 16/11/2015, the proposal, by the Office of the Deputy Commissioner Themaji, by its communication bearing number page 33, dated 16/11/2015, forwarded 24 number of proposals for settlement of land for residential purposes with eligible indigenous landless persons. And amongst those 24 number of proposals, comma, the proposal for settlement of the subject land in favor of the petitioner was also included, mentioning therein the area comma, valuation, etc. Full stop.
Petitioner's name appeared at serial number 3.
Amongst 24?
Yes.
In the year 2018, comma, the Revenue Settlement Department sent back a number of proposals, including the proposal pertaining to the petitioner for re-examination as per the checklist and resubmission thereafter to the deputy commissioner Hemaji and resubmission thereafter for further necessary action at the end of the respondent end of the respondent at the end of the revenue settlement department.
Then, my lord, another communication of DC, that is additional affidavit, lordship will find. At page 71, running page.
According to petitioner, the deputy commissioner Dhubri Hemaji
Yeah.
resubmitted the proposals for settlement of government land including the proposal for settlement of the subject land in favor of the petitioner, to the revenue settlement department, government of Assam, on 23/7/2018 by communication bearing number page 71 of the DRS 09/2008 stroke 2. DRS 09 stroke 2018 stroke 2. With the request that expeditious disposal of the proposals would facilitate settlement of land in favor of needy inhabitants of Dhemaji district. As despite initiation of the proposal for settlement of the subject land in favor of the petitioner in the year 2008, the matter of settlement of the subject land in favor of the petitioner has not been brought to its logical conclusion, the petitioner has stated that he is compelled to institute the instant litigation. Full stop. Mr. Chetri, learned counsel for the petition, has submitted that as the matter of settlement has not been brought of the subject land in favor of the petitioner has not been brought to its logical conclusion, comma, the petitioner had approached the office of the deputy commissioner on several occasions to stop. The petitioner had also submitted an application a representative stroke application. Before the deputy commissioner, comma, highlighting the above sequence of events as regards the settlement proposal, comma, by way of a on 25/11/2022, prior to institution of the writ petition. On 15/3/2023. So stop. Even after institution of the writ petition, comma, the proposal of settlement of the subject land has not been brought to its logical conclusion. He has drawn attention to the statement made by the respondent number 2 in the affidavit in opposition filed by him, to the effect that as per field verification report, comma, the subject land is in continuous possession of the petitioner till date. Para in response, comma, Mr. Goswami, Mr. Doctor and Mr. Goswami learned counsel representing the state respondents have submitted that the settlement proposal is being considered at different stages from the time to time, and admittedly, comma, the petitioner is in possession of a government plot of land, and as such, the matter of settlement of the subject plot has to be considered in terms of the land policy of the state government. So they have submitted, comma, initial, comma, that since the matter of settlement has not yet been brought to its logical conclusion, comma, writ petition can be disposed of with a direction to the respondent authorities, more particularly the respondent number 2, to bring the process to a logical conclusion in accordance with law and as per the, and more particularly, as per the provisions of the land policy. Also, para. Mr. Chetri, Learned Counsel for the petition has agreed to the said submission advanced by the Learned Counsel for the respondent state respondents. Also, para, in view of the broad consensus arrived at by the Learned Counsel for the parties in the aforestated manner, this court is of the considered view that instead of keeping this writ petition pending, the same can be disposed of with a direction to the respondent authorities, more particularly, the respondent number 2, to consider and examine the matter of settlement of the subject and in favor of the petitioner in an expeditious manner, and thereafter, to bring the same to its logical conclusion by passing a speaking order. Full stop. It is accordingly ordered. Full stop. It is further observed that considering and examining the matter of the settlement proposal in respect of the subject brought in favor of the petitioner, the respondent authorities shall take into consideration the relevant factors, including the extent of position of the subject brought by the petitioner and the provisions of the land policies, and thereafter to pass the speaking order to bring the process to its logical conclusion. It is in view of it is further observed that this court has not adverted to the merits of the claims of the petitioner as regards the settlement of the subject of his paper, and the respondent authorities are at liberty to consider the settlement proposal on its own merits and in accordance with law.
Next.
It is the entire exercise should be completed as expeditiously as possible, within an outer limit of 6 months from the date of submission of a certified copy of this order by the petitioner at the office of the respondent number 2.
my lord, in the event of sending a proposal, my lord, the authority will consider that.
I've already directed.
It will be 4 months, my lord, 6 months it will be. Can it be 4 months, my lord?
Very slow. In between, election will be there.
That is why I'm saying, my lord.
Election will be there. So after 3 months, there will be election. Everything will code of conduct.
Item number 7 for hearing. Obliged lordship.
You are in possession, so
Yes.
continue in your position. They will not disturb your position.
May I please, your lordship?
What is the case about?
Yes, your lordship. The petitioner was flying a commercial vehicle, your lordship. It is was a Tata Indica car. It used to be acted as a hired taxi. It used to be parked at the Patan Bazar railway station, and from
1
there
minute, 1 minute. Where is your petition?
petition.
Please.
No, I have flag marked the
Huh?
case laws. I have
How
given.
many?
I
Flag
have
mark.
6 cases.
I have not found your petition itself. Let me find out the petition. Thereafter case law. Is the name of the petitioner Joysaran Burman.
Jai Charan Burman. your lordship.
Yes, what is the story projected?
So what happened in this case is, lordship, the petitioner Jai Charan Burman was flying a commercial vehicle, a Tata Indica car, as hired taxi.
Flying a commerce, what
Commercial
kind of
vehicle.
Indica car?
Tata Indica car, your lordship. Then the vehicle was registered and had
Who
necessary.
is the registration?
It is on annexure number 1, your lordship, RC book. It was registered and had necessary permit from the DTO, your lordship. The said vehicle was duly insured with Oriental Insurance Company, with the policy number is at annexure number 2, your lordship. Then, your lordship, petition, shall I proceed, your lordship?
Annexer?
Annexure 2, your lordship, that is the insurance policy, your lordship.
Page.
Page number, your lordship, annexure 1 is at 11.
Annexer 1 is what?
Annexure 1 is the RC book, your lordship. Annexure 2, that is on page number 14, your lordship.
Annexer 1 is what?
RC book, your lordship.
RC book.
Yes, your lordship. The photocopy of the original was lost along with the vehicle, your lordship.
Then
We have
fitness
also-
certificate.
Yeah, this is the policy, insurance policy that which he had taken, your lordship. Then, your lordship, the petitioner had employed one driver, your lordship. The name.
Policy is up to what period? Where is the period? Okay.
It was insured in 2006, your lordship.
We are dealing with 2006 to 2007.
Yes, sir.
Okay, what happened?
Then, your lordship, the petitioner had employed one driver, your lordship. His name was Mohammed Alam Hussain, who used to ply the vehicle as a hired taxi. The taxi used to be parked at the Patan Bazar railway station, and from there onwards, passengers would come and hire a taxi for 2 or 3 or more days, your lordship. Eventually, one day, your lordship, on 14/10/2006, your lordship, the driver informed the petitioner that the vehicle was being hired and by a person to be taken to Nagaon. In earlier occasions also, your lordship, the vehicle used to get hired, so petitioner was not concerned at the time, your lordship. But in this case, on that day, petitioner did not receive any information after it was hired and taken to the Nagaon, your lordship. So petitioner made a search himself, and on 18/10/2006, petitioner filed a case at Patan Bazar PS with white case number 596 of 2006.
When? 18?
18/10/2006, your lordship. After 4 days, your lordship. Under section 392 and 342, your lordship. Then police submitted a final report, your lordship, that they could not find the vehicle, neither the vehicle nor the driver, your lordship. Then petitioner approached the Oriental Insurance Company And then he made a number of representations, and the Oriental Insurance Company
When
asked
did you first inform Oriental Insurance Company?
the day after I filed, the same day I filed the FIR, Your Lordship.
FIR,
Huh.
when did you?
1810, Your Lordship.
18?
1810 2006, Your Lordship.
1810, inform the insurance company.
Yes, Your Lordship. I have informed, and this fact has not been disputed, Your Lordship.
No, 2610.
FIR is okay. You have informed the insurance company on 1810.
1810.
Where have you stated?
It is in the petition. Date is not given in the petition, Your Lordship, but we had informed them.
You, madam, you are in writ petition.
Yes, Your Lordship. We had informed them on
Not in
after the
civil
FIR
suit.
was filed. Oh, after the with the final report, Your Lordship, of the police, maybe on
Maybe you will not do.
Lordship, on the same day we had informed.
You are not filing any plaint.
Yes,
You are
yes, sir.
filing a writ petition.
Yes, Your Lordship.
That simple facts are averred.
Yes,
And
Your Lordship.
you will lead evidence at a later point of time.
No.
Ah.
No, Your Lordship. Then, Your Lordship,
Evidently and primarily, it is a case where factual determination will fall for consideration.
no, facts of the case are
Let
not
us
disputed, Your
proceed. Otherwise,
Okay.
it is clearly a case of consumer dispute. Right?
It has a
It
jurisdiction
is
to
a
be.
clear
Yes.
case. Evidently, it is a clear case. But
Lordship, the High
on
Court has a jurisdiction.
undisputed facts,
Yes. Yes.
as an exception, we can consider.
There is no dispute of facts in this case,
Let
Your
us see. That is why I asked the first question itself.
Lordship. Okay.
When did you inform the insurance company regarding the alleged stealing of the vehicle?
Yes, Your Lordship. Yeah. Lordship, kindly come to page number 5 of the main petition, Your Lordship. Para number 6, Your Lordship.
That is FIR, okay.
No, not FIR, Your Lordship.
Para number 6 is theft and FIR. Anything?
Para number 6,
I have read.
number 5, Your Lordship. Of
Page
main
number
petition.
5, para number 6.
Yes.
I have already read.
Thereafter, he has informed his insurers, Your Lordship.
Where?
Immediately after he filed FIR and
That is very vague, madam.
it is on page, Lordship, 1, 2, 3. 8th line, Your Lordship.
Right, hereafter.
Thereafter, he has informed his insurers, and the police has registered the case. White Palton Bazaar PS case number this. He made
Where is that communication?
the first representation.
There is nothing in writing.
Yeah, not mentioned.
An oral statement is there.
Yes, Your Lordship.
Okay, who is the letter dated 11/7/2007?
Pardon, Your Lordship.
Where is their letter? Insurer's letter dated 11/7/2007.
11/7. They have sent us the last.
No, your document at
Yes.
page 15,
Yes.
paragraph 4. It says that your branch office had reported me by their letter dated 11/7/2007. Where is that letter? Then I could know that yes, prior to 11/7/2007, matter has been reported. Who is that? Not enclosed.
No, not enclosed.
Oh, you approach insurance ombudsman also.
We approach to the
Okay, okay.
state
No,
ombudsman.
let me be clear about the facts first.
Yes. Sir. Shall I proceed with the
No
case,
idea.
Lordship?
You will proceed, but also at the same time answer my queries.
11 did not understood that thing, your lordship. 11/7, I didn't understood your lordship.
We are in re-jurisdiction.
Is mentioned in your this annexure.
Annexure number
In your
3.
lecture, the lordship is asking about that.
Because your written communication has started from, as per your repetition,
Annexure number 3.
that
yes,
is
your lordship.
at page 15, 4/8/2010.
I do not have this with me, your lordship, this 11/7/2007. This your branch has reported me vital letter. I do not have this. They asked me to submit, which I have submitted, your lordship, at annexure number 5, which I submitted, your lordship. And then, your lordship, they replied me. This letter I do not have, in which they had asked me to submit the documents, but I had submitted, which is in the annexure number 5, your lordship, which I had submitted the vital documents. Annexure number 5, extra copy. It is written the extra copy of RC issued by the DPO Kamruk, final police report, original policy document, one set of keys of the
Okay,
vehicles.
you in April
I-
2010, you approached insurance ombudsman.
Yes, your lordship. After making a lot of representation, I did not receive any response whether my case was allowed or repudiated. So it was not settled. Then I went to the insurance ombudsman, your lordship.
Because I am asking that query for a reason that
Hmm.
insurance policy contains a clause that any case
Yes.
of theft is to be reported within a period of
Yes, 1 year.
1 month.
1 year. Policy number 7. 1 year, maybe, your lordship. This is one the policy number 7. It is one of their reputation clause, your lordship. I have provided the policy, your lordship. Policy number 7. your lordship.
Now what, let us read the ombudsman.
There were 2 orders of the ombudsman, your lordship. In first order, your lordship, they had allowed the petitioner's claim, your lordship.
Let us see the order. Which order?
Annexure number 4.
Huh?
No. Wait a minute. Annexure number 6, your lordship.
Let us read.
They did not appear in this, and then it was an ex parte decision.
Let us read.
Yes, your lordship. Shall I read the decision? Yes.
Hmm?
After going through the entire documents available on record, it reveals that the claim of
Where from you are reading?
the decision part, your lordship.
Okay.
Fact, page 21 of the
So shall I read?
Okay, read from where you have started.
I had started the decision. your lordship.
Okay.
After going through the entire documents available on record, it reveals that the claim of the complainant is pending with insurer since long. It is awarded that the insurer shall complete the process of settlement of the claim within 15 days from the date of receipt of the letter of acceptance of the award from the complainant. The complainant is also asked to send his letter of acceptance of the award to the insurer under intimidation to us within 1 month from the date of receipt of the copy of this award, provided the award is found to be acceptable to him. It is made clear that claim is payable. The insurance shall be liable to pay penal interest at 8% PA on the settled amount with effect from the date of submission of the claim papers till the date on which the settled amount is released. With this observation, the complaint is treated as closed. This was the first order, your lordship. Then, your lordship, I, along with the copy of this order, sent a representation to the respondent, your lordship. And then they sent me a letter, your lordship, on 19/10/2012 that they have repudiated my claim after this first order was passed. Then they appeared before the insurance ombudsman.
Where is that repudiation order?
That is, lordship, kindly see annexure number 5, annexure number 5, page number 19. Your lordship. I have the honor to beg you the following information for your consideration. So above order was handed over to Oriental Insurance Company Limited. Oriental Insurance Company Limited informed me by the letter dated 19/10/2012 about repudiation of above claim on the following grounds. And then the 3 grounds of repudiation have given abandonment of claim as per policy number 7, non-submission of vital documents like original RC, original permit, original fitness certificate, and an acknowledgement letter of DTO, and then criminal breach of trust by the insured's employee. This 3 year. So if we take this dated 19/10 till then, your lordship, the claim was neither allowed nor repudiated. So there is the policy number, the violation of policy condition number 7 will not attach here, your lordship. I'll take you to the policy, your lordship. I have submitted the policy, your lordship. This one, your lordship. I have flag marked the, so this one. This one. There it is in the file.
Okay, let us see the other part, other order.
Lordship, then the next order is at page number 7, your lordship. Sorry, page number 23, annexure number 7, your lordship. In this, your lordship, the respondent appeared before the ombudsman, and then they submitted their part, and then decision went against me, your lordship. Based upon the 3 conditions, there is
Now, what is their stand? Let us read.
Now, you are not challenging the decision of the ombudsman.
No, Your Lordship. I'm not challenging the decision of the ombudsman because, Your Lordship, in the grounds they have taken, Your Lordship, in the 3 times they have taken same ground, Your Lordship, in the before the ombudsman, when they send me the reputation of claim letter, and then Your Lordship, in the affidavit in opposition, they have not challenged the
Is
genuine.
it a correct approach that
Yes,
you
yes,
approach one authority
yes, Your
who has the jurisdiction to decide on the matter, right?
Hmm.
Like in the case in hand, ombudsman.
Hmm.
The decision is found unfavorable to you. So you leave aside that,
Hmm.
approach another authority. Writ petition without challenging that order.
I'm not.
Is it the proper way? Suppose you are not satisfied with the, suppose your writ petition is dismissed.
Mhm.
And without challenging this order, you approach consumer court.
Lordship,
You are not satisfied with the order, you approach civil court.
Lordship, this was answered in the division bench of the Guwahati High Court in Ratul Das case, Your Lordship.
But that will last.
Ratul Das, I have annexed, Your Lordship. I have submitted your copy, Your Lordship. Because they have not challenged on the genuinity of the facts of the case, Your Lordship. They are challenging on, even the ombudsman denied my case only on the basis of the criminal breach of trust on insurer's part, that is employee, and in their.
Tell me which one.
Lordship, I'll take you to this Ratul Das case. I have marked the relevant portion. Ratul Das versus Oriental Insurance Company Limited and others. Writ appeal of 2006, Your Lordship. And the judgment came in on 2008, Your Lordship. It is one of the cases that I have given, Your Lordship. Lordship, I'll take you to the para number 6, Your Lordship. I have marked the relevant portion, Your Lordship. Shall I read?
Yes.
Yes, your lordship. I'll take you to the para number 6, your lordship. This is a similar case, your lordship, exactly same facts, your lordship. However, there is no dispute to the proposition of law that Reed Court may not exercise its jurisdiction under Article 226 of the Constitution of India, where disputed question of facts is involved. Determination of which requires examination of evidences. However, where there is no dispute relating to the facts, the Reed Court can exercise a jurisdiction under Article 226 of the Constitution and issued a direction to the insurance company to indemnify the insured for the loss sustained by him strictly in the terms of contract of insurance between the parties, provided the insurance company is an authority within the meaning of 226 of the Constitution of India. Now, Lordship, I'll take you to the last portion, your Lordship. I have marked. Shall I, your Lordship? In the case in hand, it is an admitted position of fact that the
Which one? Paragraph
La-
6.
Paragraph 6, last lines, your Lordship, last 4 lines, your Lordship.
Ah.
I've marked, your Lordship. In the case in hand, it is an admitted position of the fact that the respondent insurance company is a nationalized insurance company under the provisions of the General Insurance Business Nationalization Act of 1972, and government has pervasive control over it. Hence, it is an authority within the meaning of Article 12 of the Constitution of India. Therefore, the respondent insurance company is amenable to the writ jurisdiction under the Article 226 of the Constitution of India. Now, Lordship, I'll take you to para number 9, your Lordship. Para number 9, your Lordship. 1 to 4th line, your Lordship. The only ground on which the insurance company has refused to pay the compensation is that it is a case of criminal breach of trust by the driver. There is no material before the insurance company except the registration of aforesaid first information report lodged by the appellant in the police station under section 406, 420 of IPC. To arrive at such conclusion, the insurance company at the same time did not take into consideration the report in the final form submitted by the investigating agency under section 173 CRPC, which was accepted by the learned magistrate, wherefrom it is evident that the investigating agency has reported that the case under section 406, 420, 379 IPC, though it is true, but there is a lack of material to prove. It is not a fact for the purpose of claim under the policy of insurance. The claimant has to prove the factum of theft as required under the criminal law. It would be sufficient if the factum of taking away the insured property by someone, thereby depriving the insured of it permanently, is established. In the present case, as noticed above, there is no dispute in this respect. The case is same with me, your lordship. Para number 10, your lordship.
So far as that criminal breach of trust point is concerned,
Yes, your lordship. So there is the facts of the case has never been disputed, your lordship. 3 times the 3 conditions of reputations were bring forth, but the genuinity of the facts were never questioned, your lordship. Lordship, shall I take to para number 10? So
para number
10, same case law.
I have seen it.
Dear Lordship. So this was a similar, exact same kind of case, your Lordship.
No, what are the 3 grounds for which it was?
Yes, the 3 grounds they have stated as per the affidavit in opposition, your Lordship.
What has been held by the ombudsman?
Ombudsman
Regarding
just denied.
first point.
No, your Lordship. Ombudsman denied only on one point, that is criminal breach of trust, your Lordship.
Yes,
They have just denied on page number 28, your Lordship. The last page of the petition, your Lordship. Shall I read, your Lordship?
One again. Come to page 26.
Yes, your Lordship.
3 grounds were mentioned.
Yes, your Lordship.
Now, first one is abandonment of the claim as per the policy condition number 7.
Yes, your Lordship.
Then let us read that. It appears from the self-contained note.
From the statement of the representatives of the insurer that the complainant, Mr. Jayakumar Jaicharan Burman, made request for consideration without submission of the documents on 26/3/2010, that is after 2 to 7 months, 2 years, 7 months, which attracts the policy number 7. The insurer had produced a copy of the request dated 26/3/2010 of the complaint and the terms of the conditions of the policy before the authority, which were marked as annexation number J and L. Is on perusal of the J, it is clear the complainant could not submit all the claim papers before the insurers due to non-receipt of the police final report. On a close perusal of the annexure, it is clearly mentioned in condition 7 of the policy terms and conditions that the company shall disdain liability to the insured for any claim hereunder, and such claim shall not be within 12 calendar months from the date of such disclaimer have been made of a suit in a court of law. Shall I read more?
So ombudsman also discarded that in favor, that condition in favor of the insurance company and against you.
Lordship.
It is clear.
Maybe your lordship. Let us come to their policy, your lordship. Let us come to their policy, your lordship. I have provided a copy, your lordship. Let us come to the policy number 7, your lordship. There is no pagination. 1, 2, 3, 4, 5th page, your lordship. I have flag marked it, your lordship. Police.
Yes.
So policy number 7, that this part, your lordship, para number 2, your lordship. I'll read that, your lordship. I have marked the relevant portion, your lordship. Shall I read your lordship?
Which page?
So 5th page. 2, 3, 4, 5th page, your lordship. Second part, your lordship. I have marked it. Shall I read, your lordship? It is also hereby further expressly agreed and declared that if company shall disclaim liability to the insured for any claim hereunder, such claim shall not within 12 calendar months from the date of such disclaimer have been made the subject matter of a suit in a court of law. Then the claim shall for all purposes be deemed to have been abandoned and shall not thereafter be recoverable hereunder. If we try to understand this, your lordship, if no suit has been filed within 1 year in any court after the claim has been denied by the company, then claim shall be held abandoned and shall not be recoverable, your lordship. Now, your lordship, on 4th August 2010, I made my last representation before the insurance company, your lordship. On 8th April 2011, I filed a petition before Deputy Secretary Insurance Ombudsman. And after that, on 19/10/2012, after I sent them after they received a copy of the order of the first order of the insurance ombudsman, then they sent me a letter and told me about the repudiation of the claim. So this policy condition number 7 shall not apply in my case, your lordship. There is no delay. My case was not settled. After I approached the ombudsman, insurance ombudsman,
The
then
fact of the matter is that you first inform
Hmm.
as per the ombudsman order
Hmm.
for the first time
Hmm.
by annexer J,
Hmm.
26/3/2010. Page 26.
Yeah, I'm reading that, your lordship.
Page 26.
Yes, yes, lordship.
That is their case.
That is their case.
26/3/2010. That is why I asked at the very beginning, when did you inform? Because your repetition, because I have said that is why that's what you have stated and what is the evidence on record. That is one aspect of the matter, criminal breach of trust. But so far as this part is concerned,
Hmm.
your only document appears to be page 15, 4/8/2010,
Hmm.
and next to the writ petition.
Yes.
All these are statements only.
Sir.
Writ petition is to be decided on the basis of statements made on oath
Hmm.
and precise statement, not vague statement. That is why I am asking you.
Lordship, I at this point of time do not have that document, your lordship.
So you have given a bunch of document. Had that issue had been addressed, that it apparently
Lordship.
after 3 years that claim has been lodged. Apparently after 3 years.
Lordship, they have not
You
disputed.
have given bunch of judgments.
Yes, yes, yes.
Whether any of these judgments has addressed on that point. So for the
Yes,
other
yes,
aspect,
yes, your
criminal breach of trust,
Yes, your lordship.
that has been addressed by the division bench of this court,
Yes, your
right?
Hmm.
So is there any judgment?
Yes,
Uh,
your lordship. In Jena
tell me.
construction,
Tell me.
I have given Jena construction.
Zena
Company versus the Oriental Insurance. It was
Well, come
stated.
to, okay, I'll be slow. Why you have given Tamsir
Lordship,
What kind of
lordship, their
business
policy number 7 states
link it
that.
has with Tamsir Ali?
Lordship, their policy number 7 states that I have to file my after the date of repetition within 1 year. I have to file my claim in a court of law. I have done that.
Madam, whatever decision you have to show, you have to show on the basis of writ petitions, right?
Hmm.
While glancing through these judgments, we have seen
Oh,
that there are National Consumer Commission, thereafter it reached the Supreme Court. Finding of facts are to be by the consumer forums. For example,
this policy.
please, madam,
Oh, yeah.
I am bearing with you, you also bear with me.
Case
This Om
sir.
Prakash,
Oh,
Om Prakash.
there are two cases, your
No,
lordship.
please bear with me.
First one is Jena.
Om Prakash, please bear with me.
Oh, yes, your lordship.
This I am not going to read because this has reached the Supreme Court after District Consumer Forum, State Consumer Forum, then thereafter National Consumer Disputes Redressal Commission. I'm not going to read. Not a single line from it. Next is Gurumel Singh.
Yes, your
I
lordship.
am not going to read because this is National Consumer Disputes Redressal Forum. Thereafter, it is Supreme Court. Right? Then Joina Construction Company. I am not going to read because it is after National Consumer Disputes Redressal Commission. Right? So since you have thrown a number of judgments, then National Consumer Disputes, Oriental Insurance versus Donra Surana. I'm not going to read. I'm making it clear. MR Shah, resident. What is that? State consumer. These are forums which are entrusted to deal with the question of facts. And matter reached Supreme Court after going through all these forums. Right? Tamsir Ali, we don't find any relevance. S.K. Sundaram, this is a contempt of court. 7 except Ratul Das.
Yes, sir.
On the point of criminal breach of trust, we don't find any relevance in the other judgment. What is this? Sadhana load.
That I have
What
given.
is that?
I have given that.
That has.
When there is alternative, when they have a forum, then they cannot come to under the writ jurisdiction. That one I have given. And Jaya Goel also I have given. That.
Huh? Joya?
Asha Goel. sorry.
Asa Goel.
Yes.
Yes. LIC.
Yes. So
LIC.
LIC. But then again, it went through those channels logic. But sadhana load I have given because when they have an alternative forum, this jurisdiction is not to be allowed, and very clearly Apex Court has said.
So otherwise, madam, otherwise, show me the point of limitation.
So
to lodge a claim, what is the period of limitation for filing a complaint before the consumer forum?
Within 1 year.
Within
1 year.
1 year.
Yes.
What is, suppose if you are not approaching the consumer forum, approaching the civil court, suppose, what is the period maximum?
Same period will be same, Your Lordship.
It could be 3 years maximum,
Oh.
right? Your vehicle lost in 2006.
Hmm.
You have approached this court in 2014.
Yes, yes.
That is after 8 years.
I went to the insurance ombudsman, Your Lordship. They had not repeated.
No, you
my
are
claim.
discarding that. You have not challenged that.
I am not challenging
It is not
the
a
order.
continuation of the, madam, I have seen your prayer.
Yes, yes, Your Lordship.
I have seen your prayer. That is not in challenge to the ombudsman decision.
I'm not
You are,
challenging the ombudsman.
not. It is not that you have come against the ombudsman decision. You have come straight on your own. Am I clear?
Yes, like last time I was asked to make a party. Then on the last occasion, Honorable Court told me that ombudsman don't need to be a party. So I didn't make them a party.
These are where facts have been determined by the forums, which can go into disputed questions of fact and to reach a finding on the basis of evidence to be laid by the parties, right? We are into re-jurisdiction, right? Jurisdiction to determine questions of fact are very limited, right? We are not yet sure. That is why I first asked the question, when did you lodge the claim? And from Ombudsman has recorded that it was only in 2010 you have lodged the claim before the insurance company. Right. And your vehicle was lost on 14/10/2006.
Yes, Your Lordship.
Now, when things are barred by limitation, otherwise, whether a writ petition instituted to obviate, because all forums are closed, all doors are closed by that time. Consumer forum door is closed. Civil court door is closed because of the point of limitation. Suddenly, after 8 years, you have approached this court by this writ petition. So these are few other questions. Now, let us come to again Ratul Das.
Lordship, if we
Come to Ratul Das.
yes, Your Lordship.
I am trying to find something in your favor.
Let's explore the
We cannot close our eyes on those.
no,
Let us see.
not
Let
the
us
case
see.
law, Your Lordship. If
Let
we
us
go
see
to the
Ratul
facts,
Das
Your
facts.
Lordship.
Let us see Ratul Das facts.
Yes, Your Lordship. In this case, the vehicle went missing on 24/5/2003.
24/5/2003.
Yes, your lordship.
Then perhaps claim was lost immediately. Because on 1/8/2003, branch manager, insurance company sent a letter to the insured that you
Yes.
file your claim
Yes, your lordship.
with all the documents. Then on 30/8/2003, final report was submitted after investigation and accepted the final report by the magistrate on 24/9/2003. Then insurance company repudiated the claim on 8/6/2004. Everything happened in lesser than a period of 1 year.
In my case also, I filed, your lordship. I will, lordship, in the next occasion, I will try to bring that document, your lordship.
If something is then something tallies
Yes, your lordship.
with the case of Ratul Das,
Yes, your lordship.
then only we can proceed in accordance with, otherwise facts are disputed.
Because
That is a difficulty.
I have approached the within 1 month, not even 1 month, within 10 days, I have approached the insurance company, your lordship. Even they would have.
Madam, that is why I asked the first question itself.
Yes, yes.
Am
your
I?
lordship. Yes, yes, yes.
I have seen it for the first time, but that question arose because
Yes,
this is a relevant point.
yes, your lordship.
What cannot be done directly cannot be done indirectly. If your doors are closed for consumer forum, civil court, then you cannot do this by instituting a writ petition. Am I clear?
This date of when I first made the claim.
I have read your statement, madam. Paragraph. Now I am conversant with the facts. See your paragraph 7. Also paragraph 6.
Yes.
There is nothing in writing, no documentary evidence.
The document was not
We
available
cannot
with me at that time, your lordship.
Proceed on
I will file one document, your lordship.
6-12. Knowledge. Page 10. Now what is their stand? Okay. What has not been told by you, that has been told by insurance company.
They have given all the facts. That is why ombudsman mentioned that from our PA. I can give the dates, lordship.
Lordship, on 26/3/2010, they have stated that Mr. J will made request consultation with submission of, but your lordship.
When the final report was submitted? Any idea?
Lordship, in his annexure 3, lordship, page 15, he has mentioned a date, 26/3/2010. In that letter, page 15 of the, I do not know. This is the documents they have given.
Madam, please. Madam, please.
The documents they have annexed, lordship, annexure 3. In the 1, 2, 3, 4th paragraph, however, on 26/3/2010, lordship, got it.
This was the date when I submitted final report in the insurance company, your lordship.
Lordship, repudiation, that's why I need to tell the dates, lordship. Repudiation was made in 2007 itself, lordship.
7.
Yes, because in this also, Lordship will find in this same paragraph, Lordship, the branch manager reported me by their letter dated 11/7/07. This is his own admission, his own letter that he has to submit within 5 days. If he do not,
No, what is the date of the final report? This is the date when the petitioner submitted a copy of the final report.
final report must
Oh,
have been
when?
earlier.
When?
Lordship, in the same para, 11/7/2007, I had approached them long back. Your Lordship,
Madam, what I am asking, please answer that.
the-
Don't go here and there. What was the date of final report?
we have submitted the original. I do not have the original of this police, final police report, Your Lordship. I do not have the date, Your Lordship.
They have not mentioned. They have not mentioned it. They have just given the RC book, insurance policy, and this representation. Final report is also not part of the document they have supplied to me.
You have no idea about the date of final report.
Report, I'll find out, Your Lordship. Because I have the original I have submitted to the insurance company. That is annexion number 5. The original is with them, Your Lordship, in the report.
Annexure 5 is not final report.
Not final report. Thereby, I have stated the final police report I have submitted to the insurance company. And in
No, that was the date, 26/3/2010, final report was submitted.
yes, the report came prior to that. You'll have to-
Must be.
And Your Lordship, in the same paragraph, they stated that a letter dated 11/7/2007 to submit the final report. They asked me to submit on 11/7/2007, Your Lordship. So I made my claim
From
prior to that.
7 to 10, it is 3 years.
They have made. I have
That
made
is why
claim
we
prior
said,
to that.
Lordship, 2 years.
Sometimes, this is why I'm trying to find out
Yes, sir.
what is the date of the final report. If suppose police sometimes prepare the final report maybe after 2-3 years. Till that time, the insured remains handicapped.
That's true, Lordship. But then
Because I have also seen that the matter was reported to you within 12 days.
yes, on 26. That's why
I have seen.
She was submitting my chance because I
She was
mentioned
not-
in my written statement and she written she.
That point was not addressed. In the meantime, I have seen.
Because I have also
That was never mentioned by the learned counsel for the petitioner.
yes, though I have clearly
In the
mentioned.
meantime, I have seen that 12 days, within 12 days, matter was reported. You have admitted that position.
But no
Right,
claim was
we should-
intimated to him on 31/7/07.
Whatever, but the date of final report is vital. Suppose he received the final report only after 2-3 years. And on 26/3 immediately thereafter, on 26/3/2010, the petitioner submitted the final report with the branch office. Then matter would require,
But Lordship,
might require reconsideration.
no, but Lordship.
Because you have reported the claim on the ground of failure on the part of the petitioner to submit the documents asked for by you.
No, 3 points, Lordship. One is
One.
abandonment, and I agree that
Abandon that, tell me the interpretation of this 7.
7 is Lordship, the thing.
The
It is also
interpretation
hereby further
sought
expressly.
to be given by the ombudsman. I'm not finding it convincing.
No, because
Let
it
us
is
read.
part of the year, Lordship.
Part of the okay, let us read.
Part of the ombudsman judgment, Lordship.
No. This paragraph,
It is also
clause
hereby.
condition 7.
Yes, this is the proviso.
Huh.
It is also hereby further expressly agreed and declared that if the company shall disclaim liability to the insured for any claim hereunder, and such claim shall not within 12 calendar months from the date of such disclaimer have been made the subject matter of a suit in a court of law, then the claim shall for all purposes be deemed to have been abandoned and shall not thereafter be recoverable hereafter.
When
So
you-
that means, Lordship, when we
What is the
deputy
statement? When you have informed that your
31.7
claim was repudiated?
31.707.
Where is that?
That is no claim.
Hmm? With any intimation to the petition?
Yes, paragraph 9 of our. Yes.
With any intimation?
Yes, yes. That's why he is mentioning, Lordship, because first he was given an opportunity on 11/7 to submit the documents. And then since he could not, after that it was repudiated. And that was not revealed by him in his first petition before the ombudsman. So the ombudsman said, "Ki, you consider his case." But in the second case, when we appeared, we showed all the documents which were also annexed mentioned by the ombudsman. Then the case was.
No, whether you have informed that repudiation
Yes, yes.
by writing.
Yes, by writing. That was proved before the ombudsman. That document was presented before the ombudsman, and he has gone through that.
Where is that point addressed by ombudsman?
Mm. Lordship, ombudsman order, Lordship, page 24, the B insurer, the facts that we have given down below, Lordship. The requested the complainant, Lordship, got it, down below, Lordship, down below 1, 2, 3, 4, 5. They requested the complainant to submit some documents on 17/4/07 and 25/5/07. Final reminder was given on 11/7/07. He also mentions in that letter for submission of documents within 5 days of
After,
receipt.
what line from below?
Ultimately on 31/7.
What line from bottom? You're
Lordship,
reading page 24?
Fifth end of fifth line, they. Because before that, about the FIR, they means this insurance company. They requested the complainant to submit some documents on 17/4. Lordship, got it? Down below.
Down below. They.
The document they,
Yes.
yes, they requested the complainant to submit some documents on 17/4/07 and 25/5/07. Final reminder was given on 11/7/07, 2007 for submission of the documents within 5 days of receipt of the letter. Otherwise, the claim shall be treated as no claim. Ultimately, on 31/7/2007, the claim was closed as no claim for non-submission of documents, but the complainant submitted some documents along with his letter dated 7/4/2007, original registration certificate, original fitness certificate, original permit, letter to DTO intimating the loss of the vehicle, the respect seal and signature as a vital document to prove the incident of theft were never submitted. On 26/3/2010, the complainant requested us for reconsideration of the claim without submission of the document, that is after 2 years, 7 months, which attracts the
You closed the claim on 31/7/2007, right?
Yes.
But on 7/4/2007, he submitted some documents.
No, not submitted, Lordship.
No, but the complainant submitted some documents
Along with his
along with his letter dated 7/4/2007. Full stop.
some documents.
Some
Original full stop. Original registrations are original fitness, original permit, letter from DTO intimating the loss of the vehicle having received seal and
No,
signature.
how you have closed? Have you served a copy of the repudiation to the petitioner?
Yes, it was. It was. That's why we contended that
Show me.
that was before.
Satisfy me.
Lordship, that was before
Two
the
issues are vital, whether repudiation of claim was duly conveyed to the petitioner. And secondly is date of final report.
Lordship, that was before the ombudsman. That's why the record from the ombudsman was called for. But they said it was destroyed as per law, like so many years. Within so many years, they have to destroy it. That report is also there, Lordship. With the
You might have anything on your.
We do not have, Lordship. We submitted and
Difficulty is that repetition is filed after 8 years.
Yes, and this is not maintainable, Lordship. If we go by Sadhana law, Lordship, clearly, and that Asha Goyal case also, though it is insurance, there it was decided whether writ petitions can be filed in cases where there is disputed facts because here they are disputing some dates, we are disputing some dates, and ombudsman have gone through all the documents which were submitted, and after that the judgment was passed. And they are not challenging that judgment. They are again coming against the repudiation because we already have a what I should say upper hand maybe, Lordship, that the ombudsman has given us a judgment in our favor. So how again the writ court, when that judgment is not challenged, how the writ court can touch again that same point, Lordship? Then what will happen if here, as Lordship has rightly said, if they are not satisfied here, they'll go to any other forum that, okay, we are not challenging that, but we are again coming against the repudiation.
This forum shopping is not permissible.
Yes, that is what is being done here, Lordship.
Can you find out the date of, I am giving last chance, otherwise I am finding prima facie there is no way.
Okay.
Because Ratul Das was filed within 2 years' time.
Yes, yes, Lordship.
You can survive only if it is,
The date of final report, yes.
if it is very near to 26/3/2010.
Then
Lordship,
they'll have to manipulate or something.
No, this is a police station case recorded, registered. Cannot be manipulated now.
Lordship, just one thing and to page number 26, your Lordship.
I have heard enough, I have seen enough.
Just one thing,
I
your
have gone
Lordship.
through their,
The records they were talking about, your Lordship, the ombudsman has stated that the date of repudiation is 19/10/2012. It is on page number 26, your Lordship.
madam, otherwise it is not a forum.
There is no dispute of fact, your Lordship.
No, totally dispute of fact, disputed questions of fact. We are not going to enter into that. But if the search sheet is, final report is submitted very near to 26/10/2010, we can consider some aspects.
Lordship remembers the date.
Yes.
11, it should be 11/7.
And
11/7, your
during
Lordship.
that period from the, after 12 days, that is 26/10/2014.
No, not 14. 26/10/2006, Lordship, when they
6.
informed us.
To the date near about 26/3/2010, that man might be handicapped to submit anything. We'll consider that aspect only. Otherwise, if you fail, all doors are closed. Because it will be barred by limitation. And we'll deal with the merit, maintainability. Your name, please, MS, madam?
P. Das, your Lordship.
Okay, Miss Pidas, MS Pidas, learned counsel for the petitioner, and MS RD Mojumdar, learned counsel for the
Respondent.
respondent. Let me have a look why this. Yes, MS Mojumdar, you were asked to obtain concerned records earlier.
Yes, Lordship, that is why we said, Lordship.
Then what happened?
We do not have, Lordship, because
You
this
don't have.
Adgaon branch has already been
Okay.
closed. And the from ombudsman also, Lordship will find an order for ombudsman. They have also destroyed the
Every record has a preservation period.
Yes, that under law they have given the report. Lordship. Because we submitted all the documents before the ombudsman. That was our heading.
MS Das, Land Council for the petition, has sought accommodation to intimate to find out the date of submission of final report in connection with what case number?
Lordship, Paltan Bazar.
Paltan Bazar Police Station,
596 of
case
2006.
number 596/2006. Please the case on
Lordship, long date may be given, your Lordship.
1-2.
Highly obliged. Lordship.
Deeply obliged, your Lordship.
Item number 1. Lot some unfortunate citizens of the city who were the tenants in a commercial complex called the Kothari supermarket.
It is a state council.
Yes, they were there.
Let them come. Let them come.
Yes, ma'am. They were outside of the pool. Well, if Lordship permits, my lord, I can say the facts in 2 lines.
You can say the facts before them also.
Item number 8.
What is this?
Lordship may kindly accommodate to them as my senior is out of station. Lordship may kindly fix a short date.
What is the subject matter, Mr.?
My lord, we are challenging the revenue board's judgment, my lord. It was ex parte, my lord.
Ex parte.
Ex parte, my lord. Actually, my senior also have an appointment with doctor today, my lord, since they have already informed.
Okay. Who is your senior?
D. Borba, my lord.
Okay, Mr. PK.
PK Borla, my lord, but
Learning Council appearing for the petition and MS.
A.M. DeCosta.
AL
A.M. DeCosta.
DeCosta.
On behalf of B. Koshin.
Learning Council appearing for the respondent. Private respondent. Respondent number 4.
Respondent number 4. Lordship, my name is not reflected in.
Respondent number 4. I have jointly paid for adjournment of the case. Mr. N. Goswami, learned junior government advocate, Assam, representing the state respondents, is in attendance. In view of the joint fair, our case is passed over for the day.
there is interim also, my lord.
Interim order passed. Yes, we continue.
Much obliged.
Yes, Mr. Goswami.
Item number 1, production list. What happened, my lord, some petitioners, my lord, 4 petitioners for your lordship, my lord. They are the tenants in a commercial complex called Kothari supermarket. They're situated in Basista, in the highway. They were the tenants there for since 1981. We have annexed certain documents to show that they are the tenants and they are paying the rents. All of a sudden, my lord, on 22nd of December last year,
This restaurant number 6, Someso Tumung, he came with a dozen of goons with the escorted by the Basisto PS police officials and the circle officers, out the whole premises and vandalized everything, and we have been evicted. But we have annexed photographs and covered the whole premises with tin, wall made of tin. We have been uprooted therefrom. All ingress and egress were stopped.
Uprooted
Yes,
already.
we have been already uprooted.
Huh.
Means we have been stopped from entering into the premises. We have been thrown out. We were on that day. We were in the shop itself. There are some tire shops and the repairings of shops for motor parts, and we have been stopped immediately by these goons. They were escorted by police. The more astonishing part is that they're escorted by police. We have immediately run to the police
It
station.
was on 21st December.
22nd December. On 25th of 26th December, we have approached the Honorable Chief Justice for constituting a special bench for this case. The Honorable Chief Justice was pleased to say that to move it on 3rd of January, means yesterday. Yesterday, for some reasons, it was not listed. Then we made a mention in the morning. So, my lord, now the case is, my lord, we have gone to the police station. We have filed FIR. They accepted the FIR, but they said they have raised their hands. They said we can't do anything. They are mighty people.
No, what is the extreme urgency that it has to be?
The extreme
listed
urgency
today?
is this,
Because
my lord, we have been
paragraph
stopped. My
Page
lord.
71,
My lord.
This tin sets
Yes, team said.
were erected
Not just
earlier,
temporary.
prior to filing of the writ petition.
Yes, prior to filing.
Heaven would not have fallen if it is listed tomorrow.
No, my lord, the thing is that I was trying to get the matter listed, because if the nature and character of the whole building has been changed, by the time if they demolished everything, then my lord, I lose everything, my lord. There are crores of rupees properties, the tires, motor parts, everything they have vandalized, my lord. And we have been stopped from coming in, going into.
Why officer in charge at the spot for doing this kind of thing?
No, I had talked to the circle officer. He informed me that there's some demarcation work is going on. He didn't know.
For demarcation, it is the way to demarcate.
That I don't know. That I telephoned him.
This is the way to demarcate.
There is some demarcation. He did not know about all these things.
And why officer in charge is there and circle officer is there?
It is an allegation, Lordship.
Allegation.
Of course. Now it is a stage of allegation on.
So take instruction from them.
My lord, my respectful prayer, only prayer, my lord. Let the district administration take up the area under their position.
Will not do without getting some hint of
My lord,
information.
as my friend said, my lord, circle officer informed my friend that this is a demarcation.
Let me have at least some instruction, because this is.
I'm
I thought that you are going to be evicted, right? So I without looking into that aspect, because I have been informed like that.
No,
So I thought that in
only
the case
prayer,
of-
only prayer, Lordship, because this is the innocuous prayer what I'm praying for. My lord, no further, my lord, interference by any other person except the district administration officials. There, if anyone inside,
Some basic information by tomorrow,
my lord, not Monday, my lord, Monday, my lord.
because to pass some order also, we have to know, because this has been affected already. I thought that you are going to be evicted. That is why I, without
No, my lord will
blinking
see.
my
as-
eyes,
my lord, why-
I have permitted
No,
you
my
to
lord,
list
my
whatever
respectful submission,
before the
Lordship,
close of business.
Lordship hands are not tied. Lordship hands are mighty, my lord, with the Article
But
226.
we have, that has to be, just because hands are,
No, what I'm trying to say, kindly appreciate this aspect, my lord. For a while,
okay, let him take instruction.
after the house is broken, my lord, appreciate for a while, my lord.
I am liking it to list the case tomorrow. At least have some information.
My lord, let the premises be kept vacant.
Tomorrow morning, 10:15, I'll take up. To get the information. That
Tomorrow,
in a case that you are going to be evicted or something is going on there, that without blinking my
no, my
eyes,
lord,
I have.
they have started destroying our
Mr.
rented
A.
premises.
Somala, Council for the petitioner, and Mr. N. Goswami.
2, 3 and 4. 2, 3 and 4.
Additional, sorry, Learned Junior Government Advocate Assam, for the response number 2,
2, 3 and
4 to stop. Mr. Somua, Learned Council
Monday.
representing the petitioners have submitted that by high-handed action on the part of the respondent number 3 and the respondent number 4, the petitioners have been stopped from
No, no, my lord,
operating their businesses
respondent number 6 in collusion with respondent number 3 and 4.
in collusion with the respondent number, why not 5? 6. In
Five
collusion
is-
with respondent number 6.
Yes. 5 is the landlord, my lord. He has not done anything.
In collusion with respondent number 6 have stopped the petitioners from operating their businesses from the top premises
And get out the premises by erecting tin.
to stop. It is his further submission that after evicting the petitioners from the sub premises, the entire premise has been barricaded by tins, and as a result, the petitioners are not in position to run their businesses from the said sub premises.
My friend just now said, my lord, that our shops are there, but we have not been allowed to operate our.
That is what I am saying.
Eviction, what, my lord, then if lordship says that we have been evicted, then, my lord, there may be some consequences in the civil court, my lord. We are going to file a civil suit also. That is why.
Illegal. Okay. High-handed action on the show.
The premises has been held out.
The building, where from the petitioners used to run their businesses. Building wherein some premises where from the petitioners used to run their businesses, have been barricaded by
Temporary wall by raising tin.
barricaded, and as a result, the petitioners are not in a position to enter into their shop premises and to run their businesses. এখানে লিখবো না লাগে, evicted লিখবো না লাগে. As the petitioners have alleged high-handed action on the part of the respondent number 3 and the respondent number 4 in collusion with the respondent number 6, Mr. Goswami shall obtain instructions as regards the alleged action. Tomorrow?
No, on 8th, man. On 8th. Tomorrow I have some personal difficulty.
Okay. As agreed to by the learned counsel for the parties, release the case on Monday.
8th of.
Survey copy not to do.
You give it, Mr. Somua.
My lord, I already
given. Oh, no, he has to send.
Extra.
I'm giving right now.
Whatever is alleged.
Not it. The serious allegation.
Somua learned counsel for the petitioner shall furnish 2 copies of the writ petition to Mr. Goswami during
right
the
now.
course of the day.
I'm obliged.
To enable Mr. Goswami to obtain the instructions.
Item number 9.
Yes.
Yes. In this case, my lord.
What kind of issue involved?
My lord.
What kind of issue involved?
My lord, the issue involved is, my lord, the check which was in the police custody was missing. So your lordship will come to the order dated 24/4/17, whereby this court has constituted an inquiry from the district judge. And the district judge has furnished a report that the check which was in the police custody was missing. As a result, the petitioner who was in the consumer forum has suffered a loss. That report is there. The police has also stated that it was missing during the shifting of the building.
No, no, that is not.
That is there.
No, no.
Yes, 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 yes. Your lordship, come, your
Okay,
lordship.
then, okay.
Yes.
Everything is complete now.
Lordship, lordship.
Matter can be taken up for disposal.
Yes, yes.
Huh?
So your
Then
lordship make, come
We
to this.
can, Mr. Bhattacharya, we can fix a date.
Yes,
so
yes,
that
your
we can, on a fixed date.
lordship.
Better to have it on a fixed date.
Yes.
What do you propose?
My lord, I am ready for any days.
No, because,
Even before the BU also.
no, but from a part of the next week, this court will not be available.
As your
Then
lordship.
After Bihu, it is hard.
any day.
Huh?
After Bihu, any
Any day.
Your lordship. Matter will be on the
Come
top.
quote, 6 February. I think 6-2.
6-2. Let it be on the top of the list, my lord.
It will be top of the list.
2014 matter as well.
2014 matter.
Yes, yes, yes.
Somebody may remind me.
Lordship.
I'll go through it so that
Yes, yes, yes. Lordship, this is a case.
Mr. K. Bhattacharya, Learned Counsel for the petitioner. You are who?
I am appearing for respondent number 7 and 8, pro forma respondent.
Who are they? Pro forma.
Pro forma respondent.
Okay.
I have no grievance against them
Yes,
except the state.
I have nothing.
Mr. N. Goswami, Learned Junior Government Advocate Assam for the respondent number 1, 2, 3, 4, 5, 6.
No, 6, not 5.
6.
It is Chief Judicial Mr.
Huh?
6 number.
Okay.
Yes, yes.
5.
Five. Does he any role?
Yes,
CGM?
yes. Because from their office it is missing, Lordship.
Huh?
No, no.
From
my
their
lord.
office it is missing, Lordship.
Hey, তুমি ভালকৈ report to sign.
No, no, report size.
No.
The
It is
report-
from
My lord-
Peskhana.
My lord, I'm telling you, my lord, the court has constituted an inquiry and the session judge was directed to constitute for inquiry. So CGM has submitted a report to the session judge that the check was missing from the police custody. It was not there. And that is also reflected in the report by the police itself that while shifting the office, building of the police station, it was missing.
Check is of what amount?
4,20,000, my lord.
And Mr. Yes, your name, please.
NI Khan, Lordship.
N.I. Khan. Learned Counsel for the respond number
7 and 8.
7 and 8. Mr. Goswami, 9 also?
Lordship.
9. Huh? 5, 8, 8 to 1. 6 to 1.
6-2.
Otherwise, he is to be represented by the Standing Council.
High Court.
Guwahati High Court. Okay, we can direct reflection of Mr. Ikeda. Office to reflect the name of Mr. H.K. Das, Learned Standing Council, GHC, in the respondent side in that cause list. Also, list is in the hearing column, right? On 6/2/2024, Sama has agreed to by the Learned Council.
Oblige you.
Item number 11.
We won't pursue this matter, my lord. It has become infrastructure, my lord.
Instead of waiting, you would have said at 10:15.
No, lordship, actually, we could not contact the council of the other side, lordship, so we couldn't
Okay.
mention it.
Who is the council? Mr. Goswami only?
Standing Council health.
Health, your health.
No, no.
Yes, Lordship.
Health. Okay. Mr.
A.N. Sharma, my lord, on behalf
E.N.
of
Sharma.
A.N. Sharma.
A.N. Sharma. Learned Counsel representing Mr.
S. Chamaria.
H. Chomoria. Learned Counsel for the petitioner has submitted that the subject matter of the petition has become infrastructure. MS
B. Sinha on behalf of
B. Sinha, Learned Counsel,
D. Upamanya.
on behalf of Mr. B. Gogoi,
D. Upamanya.
D. Popoino, Learned Standing Counsel, Health and Family Welfare Department for all the state respondents. Is in attendance. In view of the above submission made by Mr. Sharma, Learned Counsel appearing for the petitioners, the petition stands dismissed as infractions.
My lord.
Oblige, Lordship.